Supplementary list, item number 50.
Joint task forces then.
Lordship, the direction, Lordship directed me to appear in person in this matter.
No, there is a wrong noting that personal appearance of Mr. Actually, your Lordship passed an order that Mr. Das is appearing for all discoms. So your Lordship has directed he may be present on the next date for appearing on behalf of all the discoms. But in the noting, it is written as personal appearance of Mr. Vijay.
I thought that's some mistake.
That is wrong.
I thought
You should just read the order, sir.
I have seen the order. I thought that's some mistake I have committed.
No. So what's the position, sir?
Yes, my
Discoms?
lord.
You tell us.
We have
I'm appearing today, my lord, on behalf of OP number 4 and 7, my lord. 6 and 7 also I'm appearing. And that to my lord, the Bhatratnama is our thing. That's you kindly, I've got the instruction to appear in the 4 cases, 4 discoms, my lord. In fact, in the other seat in paragraph 7, it is mentioned that 5 discoms. In fact, it is inadvertently it is mentioned, it is 4 discoms. All right.
No, but what's the steps taken? Because there are many electrocution deaths of elephants.
With regard to that, my lord, one is at Atgad, another is in Dhenkanal, my lord. In fact, the department, the DISCOM, the junior engineer, in fact, they file FIR. That copies are with me. So what happened, my lord, in the particular first case, that is in Gita Rao case, Joint Task Force, in fact, filed 2 affidavits. These are many things are there. Also, some observation in my favor, and also some suggestions they made. So I may be this copy should be provided to me so that I can file affidavit in the next date, my lord.
No, copies not provided to you. Just
because I'm appearing today for discounts.
No, you are people instructing you have these copies, sir. 1 minute, we'll just ask Mr. Nair is here.
Yes, ma'am. Mr. Nair.
Sir, good morning, sir. This is Manoj Nair, sir.
Yes.
Sir, they have
the DISCOMs don't have the copy of that whole plan that you've given us.
Sir, all the DISCOMs, sir, have been circulated the plans time and again, sir. We have had repeated meetings with all of them.
No, my lord. They filed an affidavit. I'm asking for the affidavits. They filed 2 affidavits, my lord. For lordships, after directional lordship, then files 2 affidavits. That is an
affidavits are only the enclosures of.
That is correct. 17/4/2000.
Tell us what you have done pursuant to the action plan.
Yes.
You don't need these affidavits. These affidavits tell us about so many other issues.
And that is correct.
Whatever you have done, see, action plan is in your hands. You meaning not you, Mr. Dash.
No, that's correct.
Your clients.
Yes, that's correct.
Those 4 DISCOMs whom you are representing.
That's correct.
Have had the copies of this action plan for how many months now, Mr. Nair?
Sir, we have right from the day the order was passed, sir, we have telephonically communicated and formally communicated right from 17th of March. And subsequently, on 5th of April, we have had a complete meeting where again it was reiterated and submitted, Your Honor. And all
more than 2 months.
Yes,
your DISCOMs have these things for 2 months now.
No, Lordship, kindly see the affidavit 17/4/2023 in Gita Raut's case. I'm also I'm appearing all cases, my learned sister's case, that is Munani Padi's case. But in fact, in Gita Raut, Lordship can see this affidavit.
That is the leading case, Gita Raut.
Yes, that is the leading case. Lordship, kindly see Gita Raut case. The affidavit filed on 17/4/2023. Lordship, kindly see the affidavit page 687.
18.
Yes. That is in flag. Kette flag eta? Flag 10, I think. Flag 10, I think.
Yes.
In the flag 10, let's see, can I see, I think page mark is there 687, annexer N/1. First,
Minutes of the meeting.
Yes. In that affidavit, can I read 2 paragraphs, my lord? Because Joint Task Force is the affidavit filed by chairman, convener of the Joint Task Force. Can you see in the paragraph starts from in this regard, first, second, third, 6th paragraph, my lord. Yes. In this regard, the special chapter on preventing accidental and deliberate electrocution of elephants under thematic pillar number 2, such as the department from serial number 21 to 36 was deliberated in detail point wise in the meeting. That is in the minutes of the meeting. And chairman, joint task force, full stop. The distribution companies were requested to take necessary action on a priority basis as per the approved action plan. Then next paragraph. See Bhaskar Sarkar, such and such, CEO, TP involved, see Sumit Ghosh, such and such, Minati Prabhakar Kulkarni, Chief Operator Service, TP Del, see Dipankar Behra, such and such, and participated in the discussion and gave detailed information as regards to the mitigation measures already put in place, as well as a plan to be carried out. Full stop. It was apprised that most of the works in the elephant corridor have been completed and there is no issue of sagging and lack of maintenance of elephant movements area. An apprehension was expressed that in many cases, the elephants are roaming beyond the usual elephant movement areas, and in some cases, the municipality areas, which makes mitigation very difficult, and create threats to the life of elephants. As making the entire landscape shockproof is almost impossible. A regular coordination meeting at the level of RCCF and DFO and joint patrolling of vulnerable stretches of the transmission lines in the elephants movements area are being conducted. Then the relevant is next paragraph. A series of steps as outlined in the comprehensive action plan are being taken by the DISCOMs, such as barricading and open transformers, fixing interposing ports of both the ST and LT lines, conversion of LT wire conductor to AB cables, charging the vacuum circuit breaker, maintenance of primary substation and sensitization feeders of periodical checklist of feeder, fitting of spikes and the electric poles, establishment of elephant control room, etc. Then next paragraph. Further, a vulnerable organization, SNEHA, support of network of extension help.
No, 1 minute before you go to the next paragraph.
Yes.
This was told on 5th April. Between 5th April and today we are on 9th May. What steps, a series of steps as outlined are being taken?
Lordship, kindly see, of course, I have not filed affidavit. Lordship, kindly report. In the very report, I would think.
Sir, may I kindly intervene, sir?
Yes, please.
Sir, I just
see.
Sir, I just wanted to bring to your kind notice, sir, that this was just the minutes of a series, one of the coordinating meetings that we had.
Right.
That is by no means, sir, the first time that it was informed, sir.
Right.
So I just wanted to point out that only.
All right. No, but have they set up this elephant control room and all?
Let's kindly see on the report. A very report is there. Let's kindly see it. Is the report? But these are imposing poles. That is a vertical clearance increased into 6 meters to avoid touching of the elephants. Then let's kindly see.
No. How many such tapping? You see, what is happening is this. Villagers are just hooking on to the electrical cable, electrifying their fences. Animals come into contact with those fences and the animals die.
That's correct.
How many such instances of illegal tapping onto electrical lines have you found out in the last 2 months?
That I'll file affidavit, my lord, because today I'm appearing. So also I'll file affidavit in this aspect.
So this is not some matter where they're hearing every day.
That's correct. So
your DISCOMs know this for the last 2 months.
I'm conscious.
They can't afford to instruct you and not instruct you at all. What is the point? You're not appearing here to take an adjournment, sir. Please.
No.
Your DISCOMs are supposed to tell us what have they done.
No, I'll file affidavit in the very.
What have they? Your filing affidavit is there. What have you done?
No, Lord, in the affidavit
Is anyone from the DISCOM here?
In the report, my lord.
Is anyone from the DISCOM here?
DISCOM is not there.
CEO.
Yes. If Lordship will permit,
Nobody instructs you.
already instructed.
Who instructed you?
No, the chief head of the law is there also.
The head of law is one thing, sir.
No,
These discoms, they must be having what? I don't know what positions there are. General managers, managing directors, what is that?
CEOs. Since I'm appearing today, my lord, so I will request, my lord, give me some.
Sir, there's no question of, let me make it very clear, sir.
Correct, madam.
There's no question of, in a matter like this, appearing on that date to take an adjournment. That's not the purpose
I'm
of
not
appearing.
taking adjournment. Not taking adjournment.
Then right now tell us. If you're not taking adjournment, tell us right now.
No, Lordship can be because let's see in this affidavit, in this report, my lord, I mentioned.
This report is silent on how many cases of tapping of electricity have you detected? What action did you take?
No, with regard to that action, my lordship can see in Dhenkanal and Athkot matter, two infract matters were lost FIR immediately, the very same day.
Lodging FIR is police's work, sir. Registering FIR, investigating, all that is the policeman's work. You're the electricity company. Have you found out that illegal tapping of electricity is happening, or you don't know at all?
No, with regard to this aspect, my lord, some discussion is required on some effort.
What discussion? You have to tell us. You're the electricity company. Have you found out how many of these villages this illegal tapping has happened?
With regard to that, my lordship, can listen in that report. In that report, what are the difficulties we are facing? Last page, lordship. Last page. The challenges faced by the discoms. The last page of that report. Last page, my lord. Sorry, my lord, because the forest department DFS cooperation is 100% mandatory, my lord. That is the reason. Lordship, can you see? Paragraph 7. The development works by the other departments such as road, winding, such and such, and heightening can decrease in vertical clearance of electrical infrastructures conductors, making them more prone to animal interference in the fatalities, creating a challenge for infrastructure strengthening. Farmers in rural areas use solar fencing and house power supply to prevent crop damage by elephants. While
it's all very vague, sir.
So these
actually
are
every elephant death due to electrocution. You know which village who has tapped into the electricity line and electrified the fence. You know that. What action have you taken? And you're every time going to take action after the elephant has died, or are you going to take action before an elephant dies? That's the only question. Are you going to take any preventive action, or you're just going to wait for elephants to die and then respond?
No, we have taken some preventive action.
What preventive action have you taken? This is all very vague. What is the preventive action you've taken?
So in that report, my next page, Lordship, you can understand that the report
you've taken us to last page. I don't know if there's a next page after the last page.
In the first page is there. In the Lordship, the introduction starts. Lordship, these are the subsequently these are steps we have taken steps.
What is the date of this report?
See, that report date is that is why I said that I'll file some because
so you are told us twice or thrice that you're not taking adjournment, right? You just now told us I'm not taking adjournment, I'm not taking adjournment.
That is I'm not, because
if you say I want to do it day after tomorrow, you're taking adjournment.
No.
Since you're saying you're not taking adjournment, tell us today.
No, because I've got some documents. That is why I wanted to file affidavit.
What is the date of this document? You handed over a document. What is the date of this?
No, because the signature is on the signature is not there. So I filed a detailed affidavit so that I can appraise your lordship what is the situation and what steps you have taken till date, my lord. That's the thing.
And you're not taking adjournment. What are you doing now by making this submission? Are you taking adjournment or you're not taking adjournment?
And I'll take some adjournment. That's all.
So you went on telling us I'm not taking adjournment. I'm not taking adjournment.
No, I'm not taking because I've got some documents. That's
so you're not taking.
No, I'm taking adjournment.
Who's the CEO here? Who are the 4 CEOs?
The CEO, the central TP CEO is one there, but because 4 discoms are there, so 4 CEOs are there.
Who are they? What are the names?
The names are.
Who was instructing you? Very sorry to say, sir. They've treated this whole hearing as if it doesn't matter to them.
I'm a shooter.
Mr. Nair, tell us, since the last hearing, how many elephants have died and how many due to electrocution?
Your Honor, since last hearing till date, we have lost 4.
What is the last hearing date? 1 minute. Let's go step by step. 13 March. No, April, I think.
13th March.
13 March.
13th March.
13th March.
Okay, 13 March till date, how many?
We have lost 4 elephants, Your Honor, to electrocution since 13th of March.
4 due to electrocution.
Yes, yes, Your Honor.
And which places? Can you tell us which districts?
Yes, yes, Your Honor, yes. The first one is in Gumsur North Division, Your Honor. That is in Bhanjanagar. The second one is in Kyonjar district.
Ganjam, district Ganjam.
Ganjam.
Ganjam district. And the second one is in Kyonjar district. The third one, Your Honor, is in Bonai, that is Sundargarh district. And the fourth one is in Subarnapur district, Your Honor.
How many of these are within a corridor or outside a corridor?
Your Honor, all corridor in the sense zone, Your Honor, or?
No. You had identified elephant corridors.
Right.
And they were to take steps in all those villages in the corridors.
Right, Your Honor. So all these 4, Your Honor, is to the best of my knowledge, because we have not analyzed it in that perspective, Your Honor, but none of it falls under the 14 identified corridors to the best of my knowledge, because I've been going through it in detail.
So they're outside the corridors?
Yes, Your Honor.
No, because the thing is, these discoms were asked to take steps within the corridors or outside of the corridors also?
According to our comprehensive action plan, Your Honor, everywhere where elephant movement is there, apart from zone number 4, that is elephant exclusion zone.
No. Are they aware that they're supposed to take steps in these places?
Yes, Your Honor.
Can you give me the dates of deaths, please? These 4 deaths.
Yes, Your Honor, yes. Your Honor, the first case is on 13/3/2023, 13th of March, Your Honor. First one, that's in Gumsur North.
Right.
The second one in Kyonjar happened on 19th of March. The third one, Your Honor, which happened in Bonai, was on 11th April, 11/4/2023. And the fourth one, Your Honor, also happened on the same day, that is 11/4/2023 in Subarnapur.
All these were males, females, do we know that?
Yes, Your Honor, we have the information for that. The first case, it was Gumsur North, it was a male. The Kyonjar case, again a male, Your Honor. The female, the Bonai case was a female, and the Subarnapur was again a male, Your Honor. Female one.
All right. So each of them strayed outside a herd, is it?
Yes, Your Honor. Yes, they were all of them. Your Honor, in most of the cases of elephants getting electrocuted, we have noticed that they are not attached to a particular herd. Even if they're attached, they're loosely attached. They tend to be more peripatetic. They move around, and in the process get electrocuted. The herd might be nearby in the forest, but not as a composite herd, Your Honor. No.
So by now we must have details whether these electrocution happened with permission, without permission. Was it by illegal tapping?
Yes, we have all the information, Your Honor. Except for one that has happened in Kyonjar, where you can call it an accidental electrocution because the stay wire itself was, in short, a faulty construction of the small substation. Rest of the cases were all deliberate, where it was actually hooked, and then stakes were drawn and GI wires were charged from either LT conductor or a mainline conductor, Your Honor. In the case of Kyonjar, it was accidental in the sense that the elephant accidentally stumbled into a stay wire, which was charged because it was not properly earthed, or there was a technical reason for that. Apart from that, it's all deliberate. We've gone into the detail of each.
So what is this? They were supposed to start. This I'm referring to the minutes of 5th April.
Yes, Your Honor.
They were supposed to have an elephant control room, the discoms. Do they have that?
According to what they have told us, Your Honor, they have elephant control rooms.
What were those control rooms? Where are they set up? We don't know that.
Your Honor, we are not privy to that information.
So after that 5th April, you've not had any meetings with the discoms?
No, Your Honor. Unfortunately, I had a personal bereavement, Your Honor, which took me away for 20 days.
Right. And who's the Sneha?
Your Honor, Sneha is an NGO who has worked in Karnataka on similar issues, and the CEO of Central TPCODL had invited them over to look at the situation in Orissa and see whether they can do any intervention. And if I understand it correctly, Your Honor, they have been roped in by the TPCODL.
Because they seem to have done a saturation survey in 2 districts, Denkanar and Angul district. I don't know what the saturation survey of transmission lines. So I don't know what these.
I'm not that, Your Honor.
All right.
The Sneha's report is with me. In the hospital.
Data.
Dr. Nair, is this is the Sneha's report.
Yes, Your Honor.
So one of the things is alternative 6 feet solar or DC fence setup, as they will repel the wildlife or set off an alarm instead of creating casualty. So how? I think you need to coordinate with this discoms to make sure this happens.
Yes, Your Honor. Noted. Noted, Your Honor.
How many human lives have been lost in this same period since last hearing?
Your Honor, human deaths, we've had 20 human deaths due to elephants, Your Honor.
My God, just in 2 months.
Yes, Your Honor.
My goodness. And here again, it's along the corridors or outside?
Your Honor, it is not along the corridors per se, but it's scattered all through. I can come back to you with the fine granular this thing. It's not along the corridors per se, Your Honor. Not.
And in all these cases, are you aware if compensation has been paid?
In all the cases, compensation is being processed, Your Honor. The first installments have already been paid. That is the 10% of the total, 4 lakh rupees. And Your Honor, meanwhile, in the intervening period, there is a development that, as per our comprehensive action plan, the state government has also revised the payment of ex gratia, Your Honor. So it has been elevated from 4 to 6 lakhs now. So on an average, Your Honor, we have done an analysis of what is the turnaround time for human death payment by Anukamba, and that is working out on an average 40 days, Your Honor, as of now. So you can assume that right now it is about 40 days.
And for crop loss, what happens? How many instances of crop loss have come to notice?
Just a second, Your Honor. I'm just coming to you with the information.
Annexure Z by K. Today's affidavit. Annexure Z.
17.
But this affidavit itself is 20th April only. So more would have happened.
Yes, so last 6 months.
Crop
damage. 39.
I'm just telling you, Your Honor. I'm just taking the information.
Wow. Very long list.
It's a very long
Covering a
list.
period of 6 months. Covering a period of 6 months.
September.
We have furnished the details of payment of compensation within that 6 months duration.
Your Honor, as per your kind directions, you had asked us to do come back to you with the details of the last 6 months, Your Honor.
Yes.
And as per that, just due to elephants, Your Honor, we have had 21,093 cases, Your Honor, spread across all 40 divisions, 152 ranges. And we have paid a total amount of compensation, which amounts to 7 crore 22 lakhs, Your Honor. The rest is by wild boar, sloth bear, etc., Your Honor. And those are not significant when compared to the damage caused by elephants.
So now, let's be honest about it. How far is the plan working or not working? Because the plan is rolled out now for the last 2 months, correct?
Yes, Your Honor. Almost 2 months, yes. So, Your Honor, I am fairly confident that it is working, Your Honor. It takes a little bit of gestation period for many of the interventions. A lot of cases, Your Honor, according to me, what has happened, positive things that have happened is that at the level of the state, as well as the circle and the divisions, all three, we have been able to give a renewed focus on the entire issue. The state level high power committee has just been constituted, Your Honor, as per the comprehensive action plan. It is a very welcome step. And we'll be soon having the first meeting of that.
When was it constituted?
The notification just got, I'm just telling you, Your Honor, it just come out.
Notification, compensation, enhancement. That's the end.
Your Honor, it got notified on the 21st of April 2023.
Right.
Your Honor, 17th of April 2023. I'm sorry, it was communicated to all concerned on the 21st. 17th of April, Your Honor.
And they've not yet had a meeting.
No, Your Honor, just because of I just came back day before yesterday, Your Honor. We will soon have it.
Are the DISCOMs part of that HPC?
DISCOMs are also part of the. One second, Your Honor. We have
Yes, Chief Secretary.
Energy Secretary is part. Principal Secretary Energy is part of that, Your Honor. So special invitees will be the CEOs of the DISCOMs. So it is written that the committee may co-opt any further experts, civil society members, scientific community members.
Achha, there's another issue on this notifying elephant corridors because the NGT was seized of that issue, and I think that case is also on board today.
Yes, sir. That is.
What is the why are the elephant corridors not yet being notified?
Your Honor, if I may take 2 minutes to explain the whole process.
Yes.
So, Your Honor, across the country, not just in Orissa, Your Honor, elephant corridors are a slightly contentious issue in the sense that very dynamic process, Your Honor, keeps changing across time. And as infrastructure development and linear infrastructure particularly gets implemented in the field, elephant movement patterns change a lot, Your Honor. There are certain identified corridors where there are regular movements across two, what you call it, Your Honor, viable habitats, specifically in Western Ghats and places like that where you have large intact forest patches. So as far as Orissa is concerned, Your Honor, we have had a series of steps starting right from 2010 onwards, where there was an attempt to delineate this corridor patches. So the first attempt was 2010, then it went on and on different across years. And the last one was a specific study which was commissioned by the Forest Department of Orissa, Your Honor, that was to estimate the carrying capacity of elephants. And this was done by an organization called ANCF, headed by Dr. Sukumar. And they had given a comprehensive report, Your Honor. This is called Elephant Carrying Capacity of Orissa's Forest, submitted in January 2018. As part of that, they also went into this question of elephant corridors in Orissa. And among the 14 corridors, which was identified by the Forest Department, they found out that most of it has changed, Your Honor, actually. So they have, out of these 14, they analyzed it based on functionality and also on ecological feasibility. And they found out that only 4 of them are what they call good or is capable of elephant movement at the current times. In addition, they identified Hathibari corridor, which is a completely new corridor which was not included in that. Your Honor, if you would remember Dr. Sukumar's presentation that he gave in one of the early hearings, Your Honor, which you very kindly listened for a very long time and asked a lot of questions.
Yes.
So Dr. Sukumar, unfortunately, Your Honor, he was he's away in Congo. So he was unable to, with very poor connectivity, actually. So he expressed his inability to attend today's meeting, Your Honor. He'll be very happy to attend further hearings and give his detailed, learned opinion on this. But according to him, also, I had a discussion with him over WhatsApp yesterday, Your Honor, when he came to Signal Range. So he again re-emphasized the point that he made during his presentations, Your Honor, which is that unless we conduct, as of now, a 1 to 1.5 year old study looking at both wet and dry seasons, a detailed study looking specifically at these issues, Your Honor, it will be difficult to actually delineate the elephant movement areas or corridors, as you may call it, right now, Your Honor. And so that was what his advice was, and we have also specified the same in our action plan, Your Honor, comprehensive action plan. One of the recommendations that we give was that a study be immediately commissioned by a national agency. We haven't specified any organization or agency as such, Your Honor. Preferably by somebody who has already done corridor studies like WTI. We will
before just to stop you. I mean, you said out of 14 corridors identified, 4 are still good. I mean, still valid as corridors, right?
Yes, Your Honor. Yeah.
Why can't those 4 be notified?
Out of these 4, Your Honor, one, that is Simlipal, Hathigad, Kuldiha, after this comprehensive action plan came, we have notified it as a conservation reserve under the Wildlife Protection Act, Your Honor. So that is already in place. The rest of it, Your Honor, there are, I would like to humbly submit before the Honorable Court that in India, Your Honor, as we speak, not a single elephant corridor has been notified, specifically because of two issues, Your Honor. That is because there are no enabling legal provisions, actually, in the sense that the Wildlife Protection Act remains silent about elephant corridors or any modality of declaring elephant corridors. The conservation reserve that we declared was not as an elephant corridor. It is just happens that that area is used by elephants, and it's one of the identified 14 corridors. So the conservation reserve and community reserves are provisions that are included in the Wildlife Protection Act. But otherwise, Your Honor, Environmental Protection Act, Forest Conservation Act, Wildlife Protection Act, there are no provisions as such which gives us any clear-cut guidelines to declare elephant corridors. Number one, Your Honor, I just wanted to point it out for your notice. Second, Your Honor, we have, most of the states have declared eco-sensitive zones, which is under the Environmental Protection Act. And guidelines to that effect has been submitted, has been circulated by the MOEF, so which makes it easier for the states to go accordingly and then declare eco-sensitive zones. But unfortunately, Your Honor, we are just still waiting for guideline for declaring elephant reserves across India.
No, so if you declare my understanding is once you declare some areas an elephant corridor,
yes,
you will not permit human habitation in and around it, is it? Is there something like that?
No, Your Honor. We have, that is exactly the point, Your Honor. We don't have any clarity regarding either any act which allows us to do that or any guideline which says that. And as we speak, the Project Elephant of the Ministry of Environment and Forest is deliberating on this very same issue. They are revisiting the 101 identified elephant corridors, which Wildlife Trust of India had identified in 2017. And as we speak, Your Honor, about 50% of that work is already complete, and the team is expected to come to Odisha also, because our Chief Wildlife Warden had specifically requested for it because of these issues, Your Honor. And we soon expect, maybe within this month or next month, the team is coming to Odisha. And the whole question of declaring elephant corridors is also very much on the agenda of the MOEF, Your Honor, for your kind information.
But how is it that NGT was told that they've been identified and they just have to be notified? I think that's the impression that NGT had.
Your Honor, yes, Your Honor, you rightly pointed out. Maybe that's the position that they carried. These were the 14. We did not call it. These were not what you call it, Your Honor. These were not areas which were just waiting to be notified. These are the identified elephant movement areas which the Forest Department had identified way back in 2011, Your Honor. And we had given a detailed response to the NGT highlighting these issues, which unfortunately due to a technical error was not taken into account by the Honorable NGT. That is because when it was uploaded, Your Honor, I am told that it went into the other section of the documents and not as an affidavit. So the review petition was not considered at all. And the Honorable NGT was under the impression that it was not, the state government was trying tactics which they were trying, asking for more time, Your Honor. So now we have prayed to the Honorable NGT to consider the points which are given in the revision, in our affidavit which you have just filed, review petition which you had filed earlier. Once they go through it, Your Honor, we are very sure that they would be seized of the complexities involved in declaring elephant corridors.
So apart from the 4 electrocution deaths, I think there were poaching deaths and other deaths, right? Apart from the 4?
Yes, Your Honor. I'll just go to the breakup for your kind information, Your Honor.
Yes.
Your Honor, we had 18 deaths, of which this was something which, because we go through each and every case very, very, very stringently, Your Honor, now. Interestingly, 7 of them are calves, So this is a trend which we are noticing for the first time. We are ready to go into analyze and go into the details. Out of 18, Your Honor, 7 are just born or very young calves. As for the rest of it, the 4 electrocutions, as we already mentioned, 2 are due to disease, Your Honor. 1 died due to infighting. A male died due to infighting by injuries inflicted by another male. 1 small calf died out of trampling within the herd. It was found with concussion injuries, very small calf. And 1 incident of train accident after quite a long time, Your Honor. That also happened in Angul. So, and 7 reasons not known. So these reasons not known is because 1, either because of late detection of the carcass, Your Honor, and where the carcass is putrefied. 2nd, which are still under medical review because the samples have been sent and is being analyzed in the Center for Wildlife Health. Most of the times, these reasons not known, once the results come out, are normally ascribed to disease. It can be other reasons also, but largely ascribed to disease, Your Honor. So, in effect, 11 adult elephants and 7 calves, a total of 18 elephants, Your Honor.
Let me just of the 11 adults, 4 died due to electrocution.
Correct, Your Honor. That's right.
2 due to disease, 1 due to infighting.
Yes.
1 was a small calf. That's not an adult. Sorry.
Yes.
And that accident was again an adult.
Adult, Your Honor. Train accident was an adult. Yes.
And reasons not known is 3, is it?
Reasons not known is 7, Your Honor. 7.
But then the arithmetic doesn't work out. It's then more than 18.
I'll just read it out again, Your Honor, for you. Electrocution deaths 4, disease 2, natural deaths 2. Natural deaths 2, infighting 1, trampling 1, train accident 1, reasons not known 7. Earlier, Your Honor, we had a very coarse clumping. Now we try to go into the finer details. So that's why you have this lot of reasons coming out into the picture.
Okay. So in this total 18, 7 are young calves.
That is right. That is true, Your Honor. Yes, correct, Your Honor.
And that reasons you don't know, therefore.
We are still looking into it, Your Honor. There are various hypotheses that are being circulated. We are going into each of them. So we are really not sure what is causing it.
None of this is poaching, is it?
No, Your Honor. None of this is poaching within this time, no. And we go to each case now. Every single case is attended by a JTF team. And to the extent possible, myself.
All right. So what is the way forward? I mean, we'll get the DISCOMs to tell us what steps they're taking.
Yes, Your Honor. That would be.
And you'll have to explain what next steps are you taking, because the Sneha report seems to point out only 2 districts, though. I think they only looked at Dhenkanal and Anugul.
Athod is the
Sir, Your Honor, we had there was a discussion which took place between the CEO, TPCODL, the Chief Elect Warden, in which the Sneha representative was there. And from what I recall of the meeting, Your Honor, they're saying that they were doing pilot studies in a couple of districts, Your Honor. I'm not. They must be these 2 districts, Your Honor.
Yeah. I think only Dhenkanal and
Anugul.
Yes, Your Honor. So what we could do is we could ask them to come to us and give a detailed presentation regarding that. Look at what their findings are, and if appropriate, we can take into account some of the good practices that they are suggesting. But if I remember correctly, Your Honor, almost all the action points that they have suggested have already been included in our comprehensive action plan. In fact, they have taken a few from our action plan also.
All right.
Your Lordships, I may be allowed me to intervene with regard to the compensation issue. I may be allowed. In the last hearing, which was dated 13th March 2023, here we had this contention that there is no compensation, there is compassion payment, which has been recently increased by the government, and the amount has been changed for crop loss. In this regard, there is this Anukampa Act, through which only the owners of the land, they are having record of rights and they are getting compassion payment. But there is no compassion payment even for the sharecroppers. And there is another problem with regard to the Anukampa Act, and that is there is no exclusive differentiation with regard to the variety of crops that exist. So there is only demarcation that there is either paddy crops or the cash crops. And this, there is a very important problem also persisting with regard to this issue, because the last amendment was made in the year 2011. And after 12 years, the recent revision has come with regard
Why
to
don't you submit a note or some affidavit?
Yes,
That revision is with me, the new notification dated
We
3rd
have-
May
we have-
2023. Your Lordship may kindly have a glance. Recently it is published. So
Your
much the
Lordship-
compensation is concerned.
Your Lordship, there
Enhanced compensation. We have enhanced the compensation. This is
it
the
is
notification.
compassion payment which has been enhanced, not compensation. Compassion payment, which was earlier revised in the year 2011, and after 12 years, this new revision has come, and this is not a sustainable solution to the human-elephant conflict.
Why don't you submit a note, madam?
We have already submitted. This is flag 10, and we have
Flag
submitted
10 of what?
flag 10 of IA 640 of 2023.
1 minute, 1 minute. Just fine.
Yeah, affidavit.
That intervention has not yet been allowed.
640, all right. Were you the group that went to the NGT?
No, my lord.
Which is the group that's gone to the NGT?
That is
Lordship,
Wildlife Society of
for the
Orissa.
That is
Wildlife Society of Orissa. In the last sub-item, I am appearing on behalf of Wildlife Society of Orissa. I am representing.
Sir, you are not aware of this present PIL going on?
May I clarify a bit, Lordship, so for this case is concerned. In fact, so for the NGT order is concerned, it is of 17/8/2021. So for
No.
present-
I'm asking you, were you not aware of the present?
Yes, Lordship. Yes, Lordship. Yes. So that's why my humble submission is, so for the order of NGT is concerned, it is much prior to what your Lordship is now hearing. Your Lordship's first order in this case is of 5th July 2022. Much prior to that, on 17/8/2021, NGT has already passed its final order after hearing for 5 years. Your Lordship may kindly note this. For 5 years continuously, they heard this matter. And so for the notification...
Actually,
is concerned-
what was the year? Because there are two matters here, sir. One is a Balagopal Mishra, which was filed in 2013.
And 2013.
The present...
Lordship, I am in the last sub-item.
No, but just for your information, if you look into the cause list, sir, do you have the cause list with you?
Yes, Lordship, I have.
You will have a second writ petition, which is of 2013.
Lordship.
Are you aware of that?
No, I am not aware of that.
No. If you just look into your cause list, sir,
Yes,
you will find there's a Balagopal Mishra.
Lordship.
So that was filed in 2013.
Agreed, but it was never noticed also. notice has been-
No.
And
So there is an order
relating to
passed.
anything-
1 minute, sir. 1 minute. There is an order passed on that on 4th of October 2021.
4th October 2021.
And that was taken up, sir, along with writ petition civil 19625 of 2015 by Mrinalini Padi. And it was taken up with another writ petition Dvija Dalapati
Lordship.
22421 of 2021. And these matters have been going on for quite some time before this court, sir. You're not aware of those things.
No, Lordship, that was...
So if you go by the principle of who started it first, who passed first orders, then you're sadly mistaken to think that only NGT has been doing it.
No, Lordship, so far...
So since you are not aware, that's what I'm saying. Be careful in how you make your submission, sir.
No, Lordship, I am
Ah.
already aware of this, but so for
You are, no. Were you aware of the 2013 writ petition, 2015 writ petition?
it is in the cause list, but there has
You
been.
were not aware. You were not aware. So you
It is in
went.
the cause list.
When did you go to the NGT, sir?
I went to the NGT in 2016.
Ah, so by which
Lordship,
time there are already
my humble
three. There were
submission-
already three writ petitions here. See, the
My-
problem is this. The problem is this. You go to the NGT unaware that there are petitions here. Correct?
My humble
So the
submission.
NGT is proceeding as if the petition before it is the only petition.
Lordship,
Ah.
it is never pointed out by the state government also. They could have pointed out. They have never pointed out.
They did, sir. They did. In fact, it was noted in the NGT's order.
Which one, Lordship? Only
The
this.
pendency of these petitions was noted by the NGT in its
Yes,
order.
only 2022 petition is noted, not
Yes,
before.
yes. Ha.
Only 22 petition is.
But the long and short of it is this.
May I make a
Today
submission?
today you've heard why it's so complicated to notify an elephant corridor, because it keeps shifting. These are not permanent static corridors which the elephants somehow know that they have to go only in this route. It's not like that.
Lordship,
These
may I
things
make
keep
a submission?
shifting. Yeah.
In fact, today I am filing my IA interlocutory application for recall of the order dated 4/5/2023. Also, I am filing my wakalatnama. My colleague is there in the courtroom. So, since in fact
we have decided. I know you are more. You could think that you know more about the subject than everybody else. All right.
No.
We have got you in here so that since we are not educated enough, we are getting educated with every hearing. We are expecting that you may also benefit from these hearings. Of course, you may know much more than all of us put together.
Lordship, not. In fact, I am equally learning, and it's all a process of learning.
Unless we go with that approach, sir, because this is non-adversarial, none of us should presume that we know everything about all of this. All right.
May I make my submission, Lordship?
Yes,
Because
yes.
there is a distinction. In fact, so for the present proceeding is ongoing, it is in respect of execution application. As because there has been non-compliance of the order of NGT, and to that.
So this whole approach is what I'm reminding you about. This is not some civil suit in which a final decree has been passed, which has to be executed. You have to get out of that frame of mind, sir. Don't insist that, sir, I have a final order. It must somehow be executed. These are all live issues. Every day, the situation is changing on the ground. And there are human element. You just heard him tell you that 20 lives have been lost. Right? 20 human lives have been lost. There's been enormous crop loss. There have also been loss of elephant deaths, all avoidable. But if you start looking at it in a narrow frame, saying that I am concerned about elephant deaths, I'm not concerned about human lives, I'm not concerned about crop loss, you'll have a problem on hand. So this is not like a final decree in a civil suit which has to be executed. Which is why this needs much more sensitive approach and handling, sir. So don't insist that since I have a final order, that must somehow get executed.
No, Lordship, my humble submission is if the order of the courts and tribunals will not be respected, if at all.
No, you're mistaken there, sir. You're mistaken there. You're completely mistaken in a matter like this. When you're seeing how the ground situation is changing day by day.
Said before NGT.
And this is not static in one point in time. This is not like a civil suit. There's a dispute between A and B, whether the property belongs to A or belongs to B. This is not that kind of a litigation. This is a very different kind of a litigation.
I admit that part, Lordship. I admit. So whatever they are making the statement before Lordship, they could have said
you should not insist on something that will complicate the situation even more. Instead of providing a solution, it will add to the problems.
No, your Lordship has also asked them why not the corridors which are already
exactly, and you heard him say that. You heard him point out two major problems. One is lack of statutory provisions that permits them to do it.
That is
And
not
the
correct.
second, which he pointed out, was the eco-sensitive zones. Under the Environment Protection Act, you may have eco-sensitive zones, but that may not fully answer the kind of issues that we are faced with here.
Lordship,
And these
so
deaths, if you heard him say that, many of these deaths have occurred outside the so-called corridors. So what do you do then? You notify a corridor, deaths continue happening of both animals and humans outside these corridors. Then that's why it's complicated, sir. That's why we need experts.
Lordship, so far the enabling provisions are concerned. In fact, there is a provision.
There is no cut and dried, there's no cut and dried black and white solution in these kind of matters. And courts should not presume that the minute we pass a final order and it is not executed, the problem is, not solved. Or if it is executed, the problem is solved. That's even more, problematic. So don't use those words execution. The executions of decrees.
No execution application under section 26.
Whatever, sir. That's why I'm saying that whole frame of reference has to be different in a matter like this. Try and understand this. See what happens. We as lawyers are used to adversary litigation. I say I have a final order in my hand. It must be executed. If it is not executed, contempt of court. That whole approach has to change. There are matters, I'm not for a minute saying there are matters where they deliberately do not implement an order or delay the implementation. Those are there and we are dealing with those issues. But in this kind of a matter, see, every hearing, I don't know, speaking for myself personally, every hearing is an education for me. You may not feel that same way. You may feel that, you know everything about the issue and therefore, all that has to be done is the order that I have has to be executed. But a person like me, I feel that every hearing, there are more and more complications emerging, which we need to understand. Like 7 very young calves have died. They're themselves grappling with how did these 7 young calves die? There is something changing in nature too.
May I make my submission, Lordship?
Yes.
The Lordship has asked a question. There is no enabling provision in the law. In fact, there is a provision called as Section 3(5) of Environment Protection Act. That is what the answer is there. Even under that one, they have made a draft notification in 2012. So the draft notification is pending since 2012. The department, PCC of Wildlife, they themselves have brought this. And that is part of my, the IA that I have filed today, that is page 1516. So they have taken an attempt.
You said section 3, subsection 5.
5, lots.
Of Environment Protection Act.
Lots.
Do you have the BAR Act with you?
Yes, lots.
Just turn to section 3, sir.
Power of central government to take measures to...
First of all, how many subsections are there?
It's there, Lordship, around 40.
No. You're mistaken, sir. There are 3 subsections.
3 subsections.
Subsection 2, there are 14 clauses.
Yes, Lordship.
So when you said 3 subsection 5, there is no 3 subsection 5 at all.
Section 3, subsection 2, clause 5.
So
Yes.
now we're more on the same page now. Yes.
That's it.
Restriction
of areas in which any industries, operations or process or class of industries or operation process shall not be carried out or shall be carried out subject to certain safeguards.
This you think answers the problem, sir?
Based on this, in fact, they themselves has come out with a draft notification. That's my humble suggestion.
I'm glad that they stopped with the draft, because if, as I read it, this clause does not prohibit habitations. So it would not answer the problem, sir.
Lordship, in fact, if your Lordship see in the present regime, whatever the there are already two kinds of restrictions that is operating. One is eco-sensitive area notification, and the other is eco-sensitive zone, ESZ and ESA. So for the ESZ are concerned, it is all around the protected areas. And so for ESA, eco-sensitive areas are concerned, these are beyond the protected area. So this section 3.5 has been used to bring many other places under eco-sensitive area. So it is already there. There are many such places like Dhanu, like in Maharashtra, there are at least few places. And there are many more such notifications under which eco-sensitive area has been notified under using this one. So they have also taken help of this this section, and to that effect they have filed a draft notification.
Sir, you're not answering the question. I think you're just sidestepping it. I have pointed out to you that this clause in section 3, subsection 2 does not provide an answer to the problem that we are facing in this case. Are you aware of that, or you still want to insist that this provides the answer?
Yes, Lordship.
What is that problem? There are humans dying. There are crops being lost. Correct? Does this provide an answer to that? Or does it simply talk about industries, operations, processes which cannot be carried out?
Lordship, so far the notification are...
Sir, if you come up with half-baked, I'm sorry to say this is a half-baked response.
In fact...
Which is why I think it's correct that they've stopped with the draft notification and not notified it.
In fact,
this does not answer the problem of crop loss. This does not answer the problem of human loss.
In fact,
and this fails to understand. So this fails to understand the ground reality of elephants straying away from their herds and going away from the corridors and getting killed.
May I request? But Mr. Yes, Senvagam is there. Is chief executive of the TPC Delmalot in the BC.
Yes.
Sorry, Lordship, I was on halfway.
Yeah, Mr. Shenbagam.
Yes, sir. I am Shenbagam, CEO of TP Central Orissa Discom Limited.
So we really wanted to know, after the 5th April meeting, you seem to have had a meeting on 5th April, sir. Your counsel here drew our attention to the minutes of that meeting.
Affidavit. There's affidavit. There's affidavit.
So sorry, I didn't hear your final words, sir.
See, on 5th April,
yes, sir,
there was a meeting held in which all of you participated. It was held with the Chief Conservator of Forests, Dr. Nair, Manoj Nair, who's present here online. In another window, you can see him. There, the DISCOMs talked of steps being taken by them for barricading open transformers, fixing of interposing poles, and a whole series of steps, including establishment of what they call as elephant control room. Can you tell us your TPCODL, right?
TPCODL.
Yes, sir.
Can you tell us what steps you've taken since that 5th April meeting?
Your Honor, if you may give me a few minutes just to share not only these 2 months, but the last 3 years journey. We took
no, sir. That will. We are more concerned because, sir, in the last 2 months, we've lost 4 elephants due to electrocution. And since you had a meeting on 5th April, we'd like you to specifically tell us what did you do since then. You could even tell us from March.
Okay. So in the 4 elephant deaths, none of them were belonging to the central part of...
this is the whole problem, sir. This is the whole problem.
Irrespective of that.
Yeah. Because we can't tell an elephant you better go and get killed in where Mr. Shenbagam is holding his company, has his company. We have to have a different kind of an approach for this.
So, Your Honor, to share with you that our 24/7 Elephant Control Center was established way back on June 2020, the very year we started the operations. It works 24/7. It's in our control room, which does all the operations with the
Now, what does it do,
ground
sir?
team.
What does it do? What does this control room do?
So this control room is in touch with the Forest Department. And as the patrolling team identifies any issues on the ground, they immediately relay back asking us to carry out tripping of our live wires. So that if an elephant is going near our wires, we open the line so that it is not live. And as per our records, so far, literally 186 such incidents have been averted when elephants travel.
Yeah, no. So that is fine, sir. Suppose we're talking of your CODL area. How many CODL will cover Angul, then Canal?
Even in the areas of Satkosia, Devgar, Atgar, some part of Katak, Khurda, and a little bit of Nayagar as well.
Okay, not you don't cover Angul and then Canal.
We cover Angul and then Canal. That's the predominant area of
Now in Angul and then Canal, which is seen a lot of activity, can you tell us in the last 3 months how many instances of illegal tapping of electricity have you detected, and what action you've taken?
Yeah, so in the last 3 months, Your Honor, our preventive measures continue in terms of putting the interposing poles, putting insulated conductor cables so that there is poaching avoided in those areas. And through our 24/7 control room, whatever informations we receive, we continue to disconnect the live wires part of it. And I don't have record in terms of whether we have received a particular.
So your control room must have a panel or whatever. It has to have a board which tells you on a daily basis how many cases of illegal tapping has been detected. That's how the elephant control room should actually work. Apart from, of course, getting information from the Forest Department about movement, but you should also be able to detect illegal tapping. See, after so many deaths of due to electrocution, by now we know why it's happening and how it's happening. We'll have to devise a response to that, sir. We'll have to have a proactive response to it. See, what is happening is we're reacting after the elephant has died.
Your Honor, when we put an insulated conductor on the lines, the poaching part is eliminated. So initially, whatever corridor has been designated, we are almost on the verge of completing our work over there so that the poaching will not take place in that area.
So there is an organization called Sneha. I don't know whether you're aware of them.
Yes, it was, Your Honor, we had only arranged that because we saw them doing good work and we wanted to do work beyond what we actually carry out, and that's why we employed them to prevent accidents.
In their report, they've suggested an alternative 6-volt solar or a DC fence setup. So, are you aware of that? They've submitted a report to you.
Yeah, so once they had submitted the report, we had us in front of the Chief Secretary proposing the entire proposal which they had put across. And post that, we were advised that we should discuss with the Wildlife Department to see how we can take that further. We did have that, our team did have a meeting along with Sneha, and they have agreed over a set of actions to be carried out. And we would be now taking forward that with our.
It will have to be both time bound and immediate, sir. So the thing is, this kind of a problem that we are now faced with, I think requires far more urgent action than what is right now happening. I think we should straight away start identifying stretches of whatever, where you can have this alternative 6V solar fence set up.
So we are fully aligned with that approach, and we would discuss.
So what as a court, what we expect is, sir, that you drop this time-bound action plan of replacing as much as you can all these electric fences. How do you disincentivize tapping of electricity? What are the steps you're taking to disincentivize it? Because villagers will continue, because they need to protect their crops, they need to protect themselves from wild boars, from elephants, from all wild animals. It's only natural that they'll want to protect themselves. So you need to talk to the villagers where this is happening. While you even disconnect the illegal tapping, you have to offer them this alternative of 6V solar fences. Otherwise, it will continue to happen. You disconnect today, day after, again, it will come back. So this will need more intensive interaction with villagers to convince them why they should go for these solar voltage fences.
I fully agree. And what we would do is our entire action plan in terms of how we would taking for whatever we are doing now and what we intend to do very clearly, we will share it. And I must also share that the government of Orissa supports us with funds in terms of ensuring that the lines, as I said, are lifted up as well as the insulated conductor are placed. And that status also we will share with you. But what we also do as a company is continue to work rural village people, right from carrying out safety jingles. We have got safety awareness drives, even in the schools part of it. And we continue to educate the villagers to see that they avoid the poaching part of it or the hooking part of it.
No, but we'll have to actually take it there, sir. We'll have to give them the alternative then and there. Even if you de-hook, you have to say, here is that other alternative, set this up instead. Otherwise, just talking to them will not get them to do it. They'll actually have to see that alternate and how it works.
Yeah, very true, Your Honor. And
I would suggest that all your counterparts of the other 3 DISCOMs, I think you have a round table. It could be a virtual round table. Have it in the next 3-4 days or maybe maximum a week, and drop a kind of a uniform plan of action so that in all your areas you can roll it out immediately.
We will do that, Your Honor.
All right. And we are going to trouble you to continue to participate online on the next hearing also.
Privilege, sir, to be part of this effort to reduce the elephant deaths.
All right.
Lordship, I may be pardoned to say something. I am in one IA 3126/23, Lordship.
Yes.
This is in this case, Lordship, what has happened? Around 40 elephants, they have migrated from Chandka Wildlife Division to Khordha and Noyagad border. That is a place called Ronda minor irrigation area, Lordship.
Right.
The Chief Wildlife Warden and also the DFO Khordha is aware of this fact. And at presently, around 40 elephants are there in those forest range areas, Lordship. And so far as the petition, the intervenor application is concerned, personally affected because having 4 acres of land. Till date, we have not got a single pipe of compensation from the department. What we are praying, Lordship, in this case, we request to the department to have a solar fencing to an area so that can restrict the human habitat and also to the forest range.
All right.
That the DFO Khordha is aware of this fact.
All right, sir.
And the Chief Wildlife Warden, Mr. Papli, also is also aware of this fact. We have sent our application to them. So what we pray, Lordship, let the forest department be directed along with the Chief Wildlife Warden to have a solar fencing of this area.
All right.
And that is another part, Lordship. One female elephant, Lordship, died because of the electrocution. One female elephant died because of the electrocution. What has happened to that deep forest area for these industrial activities? They are giving new connection. That is under this central division jurisdiction, Lordship. So in the forest range of Tangi, that is under the DFO Khordha and under the forest range of Ranpur, the industrial establishment which they are going to give new connection of electricity, they may, before giving the connection, do a field survey how that can affect to this wildlife and the elephant existence in those areas. Lordship, we welcome the elephants to be there, but side by side the core protection measures which are to be adopted by the department, let them to adapt it in a proper manner so that the persons, those the farmers, those who are losing their crops, and because of fear they are not also doing the cultivation because of the existence of around 40 elephants in those areas. The forest department may kindly take care of all those.
All right.
Your Lordship,
Lordship,
your Lordship,
the-
intervention application 640, flag number 10 may be allowed.
Yes.
Intervention.
Yes, please. Yes, Mr. Pani, you wanted to say something?
Lordship, in the last sub-item, my wakalatnama and IA may be taken on record.
Yes, yes, we'll take it on record. We'll take it on record.
Lordship, my humble submission is that your Lordship has been given a wrong impression that there is a parallel proceeding. In fact, the proceeding has already been completed since 21. So that part one. And second thing, so for this order has been concerned, the 354523 order is concerned. It has been obtained fraudulently, Lordship. Your Lordship has given a
Fraudulently.
yes, Lordship has given impression that your Lordship's order has been communicated to Honorable NGT. That is not correct. In fact, they have already placed on record the documents which have been placed with NGT. None of the document suggest any of your Lordship's order have been communicated to Honorable NGT. That part is there.
It's not like the NGT was on.
Dr. Nair,
Yes, sir.
what is this latest update on the criminal cases?
We filed another.
Your Honor, our additional SP is here with all the details, with all the
That
specific.
additional affidavit we have filed.
Which is
The other second affidavit.
That's also filed on the same day, 17.
Same day, 7. That is by Jatindra Kumar Panda,
My Lord, namaskar.
additional SP.
This is additional SP Jatindra Kumar Panda. In the last hearing, my Lord, on 13/3/2023, at paragraph 4, Honorable Court had ordered me to apprise the Honorable Court about the progress of investigation in 6 specific cases. I have submitted the status reports obtained from the concerned DFOs in my affidavit. In brief, I am appraising Miller in case of Ghumsar division. In that case, 2 accused persons, one accused was arrested at the time of filing of affidavit, and subsequently another has been arrested, and one more accused is yet to be arrested, who is absconding, and we are searching that accused. About Simripal North Division case, my Lord, we have successfully recovered the tusks of the elephant, both the tusks, and arrested 4 accused persons. They were arrested and forwarded, and in the meanwhile, charge sheet final prosecution report has already been submitted on 27th March 2023. In Arthagad division case, my Lord, in both the cases, accused persons are absconding, and there was a incident for which accused persons, one of the suspects died in custody of the forest officials, for which 4 forest officials have been arrested and forwarded in a specific case under the charge 302 and other sections. In both the cases, as the accused persons are absconding, we have obtained NBWs from the honorable local magistrate, and those NBWs have been entrusted to police stations, and they are trying on getting severe and SDR analysis. They will be arrested very shortly, my lord. As regard Simlipal South Division case, that was a poaching case, my lord. In that case, also we have arrested one accused in the meanwhile, and both the tasks have already been recovered. We are in search of 3-4 remaining accused persons. They are also absconding, and they will be arrested also shortly. And after their arrest, final prosecution report will be submitted. In Henkanal case, my lord, the accused has already been arrested. That was a electrocution case. That was the incident of 12th March, just day before the previous hearing. In that case, accused has been arrested, and final prosecution report has already been submitted, my lord.
All right.
My lord, there was a direction in the last order for submission of charge sheet in Jasipur case, which was filed under section 302, and subsequently during investigation.
Jasipur IIC is also present as per your lordship's direction. I think IIC Jasipur is also present.
All right.
Whatever you have said, that is there in the affidavit.
Yes. All right. You say, pursuant to the order passed.
My lord, may I make a small suggestions to your lordship? Is that we are, if any representatives of the DISCOMs could be part of the joint task force, so that they can think on the same page.
They're all already there.
Is it?
They're all already there. They're being called for every meeting. Mr. Shenbagam was here just now.
Senbek is there, I think.
Yeah. And I think that Energy Secretary is part of the HPC.
Yes.
They're all going to be invitees to that HPC. So that will come.
Lordship, in IA 3126 by 23, is the government has filed any counter, Lordship? Just government advocate is there.
We have not filed any counter.
All right.
Lordship, let them file the counter in this case,
All right.
Lordship. 3126.
All right.
Just to assist your lordship, my lords, regarding the notification of those corridors, I'm appealing virtual mode.
Yes.
This notification, one corridor, Mr. Nair submitted that one corridor was notified. That
Not as a corridor,
Not corridor.
only as a conserve area.
Yes.
Reserve
This
area.
was the subject matter of a Supreme Court SLP by civil appeal number 1627/28 of 2022, dated 2nd March 2022. So pursuant to the directions of the Honorable Supreme Court, they have notified that one corridor. So that is something which I wanted to draw your lordship's attention. So this notification of corridors as it fell from Mr. Nair is a ticklish issue. So state government had identified 14 corridors way back in 2010. That remains, as it fell from him, that remains how they will notify them. But the Supreme Court also had directed, so far as one corridor is concerned, that order, if my lord can just have a look. Because that will also have a bearing so far as these NGT orders, this court's order.
Where is that order?
So that order, my lord, has I'll provide them. I'm appearing virtual, so I'm not able to show. That is civil appeal number 1627 of 2022. Order dated 2nd March 2022. Bench of Honorable Justice Nageshwar Rao had passed that order pursuant to stone quarry operations. So basically, the conflict is between mining activity and notification of these corridors. I just wanted to bring this order to the notice of the court.
All right.
That's it. I don't want to encroach upon anybody else's territory.
1627.
So this is the subject matter of a Supreme Court order also.
All right.
Lordship, the elephant disturbance in the Tangi range is particularly because of the mining activities, Lordship, which the DFO Khurda and the PCCF wildlife also were aware of this fact.
All right. So pursuant to the order passed by this court on 13th March 2023, two affidavits have been filed. Full stop. One is by the chairperson cum convener of the Joint Task Force (JTF), Dr. Manoj Nair, Sorry.
It's
there. This is there. Dated 17th April 2023. Providing information as regards compensation paid in respect of human losses, human injuries, animal losses, house damage, and crop damage. Full stop. There have been 21,093 cases of crop loss. Full stop. Dr. Nair, who appears in virtual mode, informed the court that a sum of rupees 7.22 crores will be paid. Stop. The court has also been shown copy of a notification dated 3rd May 2023, issued under Rule 45 KK of the Wildlife Protection Odisha Amendment Rules 2023, enhancing the amounts of compassionate payment in all of the above categories. So, for instance, the ex gratia for human loss has been increased from 4 to 6 lakhs. Full stop. According to Dr. Nair, there is a 40-day turnaround time for payment of compensation. Paragraph. It appears that on 5th April 2023, there was a meeting held by the chairperson of the JTF with the DISCOMs, where, among other things, a discussion was held on the mitigation measures that have to be put in place for avoiding deaths of elephants due to electrocution. Full stop. The series of steps contemplated pursuant to the Comprehensive Action Plan, CAP, to be taken by the DISCOMs include, open quotation, barricading the open transformers, fixing of interposing poles of both HT and LT lines, conversion of LT bare conductor to AB cable, change of all right. Change of vacuum circuit breaker, maintenance of primary substation, sensitization of feeders, and periodic checklist of feeder, fitting of spikes in the electric poles, establishment of telephone control room, etc. The minutes also refer to a study undertaken by SNEHA, SNEHA, bracket, Support for Network and Extension Help Agency, bracket, having experience in working on human-elephant conflict issues in Karnataka, being engaged with the DISCOMs to undertake a study. Stop. Mr. Dashlan, counsel appearing for the DISCOMs, has handed over a copy of a report submitted by SNEHA to Tata Power Limited, Mumbai, where inter alia, one suggestion given is for use of alternate 6V solar or DC fence setup, which will merely, single quotes, repel the wildlife or set off an alarm instead of creating casualty. Full stop, unquote. One of the interveners in IA number 3126 of 2020 has also asked for similar measures to be deployed in the villages of those applicants after undertaking a ground survey. Full stop. Paragraph. Mr. Shenbagam, who is the CEO of the TPCODL, was present online and explained that elephant control rooms have been set up by the DISCOMs since 2020, and that advanced information of elephant movement received from the Forest Department, they're able to take corrective action. Full stop. However, more intensive steps would have to be taken by the DISCOMs to interact with the villages falling within their respective areas and which have witnessed elephant movements in the past, persuading the villagers to go in for 6 feet solar fencing and offering that as a viable alternative, even while disconnecting the illegally single quotes hooked unquote electricity connections, which are powering the ad hoc electric fences put up by the villagers to prevent attacks of wild animals, either on the humans or on the crops. Paragraph. Dr. Nair placed before the court the statistics of elephant deaths and human deaths in the past 2 months. Full stop. On 9th March, an adult male elephant was electrocuted in Kyonjar. And on 13th March, another male was electrocuted in Gumsar in Ganjam district. Full stop. On 11th April 2023, one adult female elephant and an adult male elephant were electrocuted in Bonai and Suvarnapur respectively. Full stop. Apart from the 4 electrocution deaths, there have been in the last 2 months 14 more deaths. 2 of elephants, 2 due to disease, 2 due to natural causes, 1 due to infighting. And 1 due to a train accident. Full stop. Of 18 elephants that have died, there have been 11 adults, bracket, including the above instances of deaths, bracket, and 7 very young calves. Stop. Dr. Nair adds that the reasons for the deaths of these 7 very young calves is still being analyzed. Full stop. During this period, 20 persons have lost their lives due to attacks by elephants. Full stop. Dr. Nair adds that these deaths have occurred in areas not necessarily aligned to the elephant corridors that were earlier identified. Full stop. Originally, 14 elephant corridors were identified by the Forest Department in Odisha. But due to passage of time, only 4 continue to be identified as such. And of these 4, one has been notified as a conservation reserve pursuant to an order passed by the Supreme Court of India on
2nd of March.
2nd March 2022 in Civil Appeal number 1627 of 2022. Paragraph. It must be noted here that the Wildlife Society of Orissa (Elephant Corridors) had approached the National Green Tribunal (NGT) with a petition with a petition OA number 129 of 2016. Questioning the inordinate delay on behalf of the state of Odisha in notifying elephant corridors under Section 3 of the Environment Protection Act 1986 EPA, read with Rule 6 of the Environment Protection Rules 1986. Paragraph. It must be noted here that in the said application, the NGT appears to have passed a single court's final order on 17th August 2021. Directing the state of Orissa to notify the 14 elephant corridors as earlier identified by the Asian Nature Conservation Foundation (ANCF) within a period of 2 months. Full stop. This led to the state of Orissa filing a review petition. Pointing out that writ petition civil 275/2015 is pending before the Supreme Court on the issue of securing elephant corridors in Odisha. Further, it was pointed out the report of the ANCF suggests that, open quotation, most of the corridors has no functional existence, and most of the corridors are also not ecologically feasible. Full stop, unquote. Accordingly, the review is sought of the order dated 17th August 2021 of the NGT. Has this review petition been dealt with by the NGT?
No, my lords.
All right. Even
There's
while
not
the review petition was pending,
There is no number of review
That's the
petition.
issue.
all right. Execution application number 3/2022/EZ appears to be filed by the Wildlife Society of Odisha, pressing for execution of the order dated 17 August 2021, in which the NGT passed an order on 6th April 2023 granting the state 1 month's time, open quotation, and no more, unquote, to notify the elephant corridors. Stop. By this time, in the hearing of the execution petition, it was brought to the notice of the NGT by the state of Odisha that this court was seized of the present petition, one of the present petitions, that is WP Civil PIL number 14706 of 2022 on the same issue. Paragraph. Against the said order dated 6th April 2023, the state of Orissa has filed WP Civil 14057 of 2023, in which this court passed an order on 4th May 2023, staying the further proceedings before the NGT. Paragraph. The respondent opposite party in the said writ petition is the Wildlife Society of Odisha (Elephant Corridors), who are present today through their advocate Sri Shankar Prasad Pani, who has filed an IA seeking vacation of the aforementioned order dated 4th May 2023. So the said IA is directed to be registered by the registry. Full stop. Notice is directed to issue in the said IA, which is accepted by Council for the State of Odisha, who undertakes to file a reply thereto within 4 weeks. The rejoinder that to be filed before the next date. Paragraph. Dr. Nair has explained two major problems coming in the way of notifying elephant corridors. Most of the first being that there is no legal provision in the Wildlife Protection Act 1986 (WP Act) which permits such notification. Full stop. The second is that the EP Act only talks of eco-sensitive zones, which does not fully answer the need for a comprehensive provision for this purpose. Paragraph. Mr. Pani, Learned Counsel appearing for the Wildlife Society of Odisha, sought to counter the submission by referring to section 3 bracket 2 bracket 5 of the EP Act. Which empowers the central government to take single quotes measures to protect and improve environment, unquote. And in that process, notify restriction of areas, open quotation, in which any industries, operations or processes or class of industries, operations or processes shall not be carried out or shall be carried out subject to certain safeguards, unquote. Paragraph. In the considered view of the court, section 3 bracket 2 bracket Roman small 5 of the EP Act operates in a very narrow sphere, as it doesn't contemplate loss of human lives, crops and vegetation, etc., as a result of movement of wild animals, including elephants. And it is doubtful, therefore, if a measure taken under the above provision would answer the problem brought about as a result of elephant-human conflict. Full stop. Paragraph. In any event, it does appear that identifying elephant corridors precisely is a complex task, as pointed out by the ACNS, and which was also voiced today during the course of hearing by Dr. Nair. Stop. It is significant that many of the deaths that this court has noted in the present order and the earlier orders of elephants and humans have occurred in areas not strictly in and around the elephant corridors earlier identified. Full stop. Paragraph. Consequently, at this stage, the court does not consider it advisable to vacate the order passed by it on 5th April 2023. On 4th May 2023 in WP Civil 14057 of 2023, and would consider that question after the responses are received to the application filed today by the Wildlife Society of Orissa, bracket elephant corridors. Paragraph. In the considered view of the court, not enough steps have been taken to prevent deaths of elephants due to electrocution in Odisha. Full stop. This is despite the CAP being made available to the DISCOMs for over 2 months now. For nearly 2 months now. Full stop. A direction is issued that the CEOs of the 4 DISCOMs will immediately convene a meeting within a week from today, in which the chairperson of the Joint Task Force of the JTF will also participate and chalk out a time-bound plan for completing a survey of all the villages in their respective zones which have witnessed movement of wild animals, attacks by wild animals, destruction of crops, and deaths of wild animals due to electrocution. And roll out a plan for replacing of the electric fences wherever found with solar powered fences as suggested by SNEHA, SNEHA. Full stop. It is absolutely essential for the DISCOMs to immediately identify all such instances of illegal hooking of electricity transmission lines to power such electric fences illegally put up in the villages and discontinue the practice forthwith. Full stop. Sensitization meeting with the villages by officials of the DISCOMs required to be undertaken in coordination with the forest officials. Full stop. The court would like to be informed by the next date of the exact extent of such 6V solar powered public DC fences that have been erected in place of the electric fences which were earlier being used. Paragraph. The second affidavit has been filed by the by Shri J.K. Panda, additional SP and a member of the JTF, where the details of the 6 ongoing criminal cases that have been registered in Atagad, Simlipal, Gumsur and Dhenkanal divisions have been set out. Full stop. The court is assured by Mr. Panda that all possible steps are being taken to carry each of the criminal cases to the logical end by completing investigation, filing charge sheets, arresting the persons accused, and ensuring that the case progresses. Full stop. A further updated affidavit, updating the status of these criminal cases be filed for the next date. Paragraph. The intervener in IA 640 of 2023 has prayed for processing of all compensation claims for loss of human lives and crop loss by the state government, and for all such claims to be settled in a time-bound manner. Stop. Has notice gone in this?
Your Lordship, copy has been served.
Yeah, notice was issued in this IA on 13 March 2023, and no replies have yet been filed. Full stop. Meanwhile, an additional affidavit has been filed by the intervener on 5th May 2023. Have you served this copy?
Your Lordship, yes.
You have served copies?
Yes.
Copies of which have been already served on counsel with the state.
We haven't served the copy to the petitioner.
So copy thereof we served counsel to the petitioners as well as other counsel appearing today. Replies to the both IA number 640 of 2023 and 3126 of 2020 will be filed by the state.
3126 of 23, Lordship.
23, all right, will be filed by the state. In 3126 of 2023, notice is not gone.
That we have also not received any
Correct.
copy in
Correct.
Mr. Biswala's case.
Correct.
Lordship, I have sought the copy. The receipt
Anyway,
is
serve
there.
it today again, sir. Be
You again
filed within 4 days, 4 weeks.
In the meantime, perhaps
And
the
rejoinder
DFO
before the
could
next
have
stage.
filed the counter, Lordship.
All right.
Lordship,
You say Dr. Nair informed the court that on 17th April 2023, a high part committee has been constituted with the principal secretary bracket energy being one of the members and all the discoms being the special invitees. Full stop. He informed the court that the HPC would meet very soon. Full stop. Apart from inviting the discoms, the court directs that the applicants, representative of the applicants in IA 640 of 2023 and 3126 of 2023 also be invited to present their issues before the said committee. Full stop. The court, the HPC will also invite Sneha, apart from Dr. Sukumar, to participate in virtual mode at its meeting. Stop. The minutes of the meeting of the HPC be placed before the court along with an affidavit before the next day. Paragraph. Dr. Nair will file his affidavit explaining the progress in the implementation of the CAP. Stop. List on a date in July. July.
My lord, we'll invite the lawyers. To
That's
that
up to you, sir.
No, representative, your lordship has said, or because one of the petitioner is the
Yeah, if they
associate.
want to be represented by the lawyer, let them send the lawyers. No problem. They'll indicate.
May I request, my lord, one thing? Let the copy of repetition of the all petitions may be served to me because I'm appearing today.
So you just bring a pen drive,
Yes, yes, sir.
give it to him. Within 5 minutes, he'll give you the entire copy. And don't stand on technicalities.
Well, that's correct.
Everybody knows everything now. Don't wait for being served this copy and that copy. Whatever you have to do, you start doing.
My lord, I pray this matter may be listed on the last week of June, my lord. Because last week, that is on 19th July, we told it.
Yeah.
10:30.
All right.
Supplemental list for orders, item number 1.
item 1, my lords. I am for the petitioner. No instruction, my lords. Item 1.
Dismissed. No instructions dismissed. Right.
Item number 2.
Item 2.
What are you saying, sir?
Item 2.
Item 2, my lord, I am appealing virtual mode. And for the petitioner, my lord, permitted withdraw, my lord.
All right. Dismisses withdraw. All right.
With liberty to file a better application.
All right. With liberty to file a better.
Item number 3.
Sir, adjourn this matter for next week. I'll produce the second copy plus additional documentation.
All right. At the request of petitioner who appears in person, list on 4th July, defects be cured in the meanwhile.
Item number 4.
My lord, in item number 4, in course of the day, second copy in course of the day, let it come 1 week after.
What's the matter about, sir?
My lord, it is challenging the sale notice because the land was given by the government. Tata constructed a hospital, super specialist hospital at Barampur, but Tata is now selling that, page 13, my lord. a sale notice that has been challenged. Tata is selling. The prayer is the government should take up that super specialty hospital, which helped a lot during the corona period. We are sufferer of the villager. That super specialist hospital was constructed over the donated land by the government of India.
It's all over, sir. Bid submission day is 28th February.
Pardon?
Come to page 13, sir. 1-3.
Yes, yes. It has not been sold. It has not been, no progress has been made.
How do you know that?
Yes, my lord.
How do you know that, sir? We are saying yes. How do you know?
Because it is a 15 days notice. No buyer has gone there, no application.
How do you know, sir? How do you know?
That is my instruction, man.
No.
The government is
made in representation, nothing.
We have filed the representation, my lord. We may file a fresh representation detailing the fact may be considered.
All right. The petitioner seeks leave to withdraw the present petition with liberty to file first a representation and then after following up its
stipulation may be given, my lord,
to seek appropriate remedies in accordance with.
My lord, stipulation may be given. The government is to take care of.
This post office withdrawn, liberty is paid for. All right.
Item number 5. Item 5.
Pass it.
Item number 6.
May I plead your lordship? The fact remains is that the registry has pointed out certain defects in that. In fact, in page number 37, due to oversight, has not been scanned and filed. But there are certain defects are there, which I need to cure. It is a curable defect. The lordship may grant a short time in which I can able to clear the defect. And thereafter, your lordships can fix the time for hearing. So may I request any date may be fixed by your lordships immediate after vacation, subject to your lordships' convenience, so that I can cure the defects and your lordships can hear and dispose it of. The fact remains is that, my lord, the writ petitions 31182 of 2020 was dismissed at the stage of the admission without any counter from the respondents, alleging that there is no defect said to have been committed by the respondents. The brief facts of the case are like this, my lord. The fact remains is that there was a notification which was sought in the year 2013 for selling of certain plots by the respondents, and in response to that, the prerequisites and the application was submitted in 2013 itself. But there was no response to the 2014, and a representation was given asking the authorities to clarify as to whether the application which was submitted by the petitioner was considered or rejected. But there was no response. Then a writ petition was filed before the Supreme Court.
All right. You just say list on 31st July, defects be cured in the meanwhile as a last chance.
Item number 7.
7 and 8 both are arising out of same matter, two judgments of, but there has been delay. Delay was because of we approached the Honorable Supreme Court. Lordship, I have quoted the order at page 6 of the Honorable Supreme Court. Initially, we had challenged that in the Supreme Court. The petitions challenging the basic order dated 10/8, where delay is more than 1100 days, and the petition, they categorized the matter into two parts. First is the delay in filing the SLP, and second is the merit of the order. So far as the delay in filing the SLP is concerned, they dismissed on the ground of delay, and we were permitted to withdraw to file writ appeal.
No, they've said appropriate proceedings. That's all.
No, category 2, Your Lordship. Insofar as the matters falling under category are concerned, those petitions are dismissed on ground of delay. I'm sorry. Category 1, sorry. Reproduction and counsel in support of the petition seeks leave of this court to withdraw the matters falling under category stating inter alia. The petitioners may, if so advised, file writ appeal.
So writ appeal delay can't be condoned. See, when the writ, especially petitions is themselves delayed,
SLP petition was delayed.
So how is a writ appeal be even more delayed?
They rejected on the ground of delay.
Correct.
And
you only said we'll permit, we want to challenge the writ appeal.
That is the reason we have given. After this order, we have come.
No, but normally the Supreme Court should say if a writ appeal is filed, delay will stand control. That's what said.
The other order was not necessary, but anyway, they have permitted us to move that, Your Lordship.
Yeah, you see, against the impugned order dated 10th August 2017 of the single judge, the present petitioner appellants had filed SLP Civil Diary number 2903 of 2021, which was disposed of on 15 February 2021 with the following order. Reproduce the order at bottom of page 6, the whole of page 7, and up to whole of page 7. Then you say, Mr. Martil and senior counsel points out that the present case falls under category 1, where the Supreme Court, while dismissing the SLPs, has withdrawn, granted liberty to file a writ appeal, single quotes, if so advised, unquote, full stop. As noted herein before, the SLP itself was time barred, was badly delayed, even when it was filed at the Supreme Court nearly 4 years after the impugned order in 2021. Consequently, the present writ appeal also is equally barred by time. Full stop. Even excluding the time during which the SLPs were pending in the Supreme Court, the present writ appeals would anyway be barred by time. Full stop. From
the order,
the delay is in fact of 866 days.
From the order of the Honorable Supreme Court, it's not barred.
If you exclude
previous years, that's
it should be more than 866. It's an 8/2/2017 order. Full stop. This excludes even the period during which order of the Supreme Court for delay in matters due to the COVID-19 pandemic. Full stop. In other words, after excluding the period during which the COVID-19 pandemic was prevalent, there is still a delay of 866 days in filing the writ appeal, which has not been satisfactorily explained, and for which there was no order from the Supreme Court of India for this court to condone the delay. Paragraph. Consequently, IA number 722 of 2021 for condonation of delay is hereby dismissed. Consequently, the writ appeal is dismissed.
Same.
Both 7 and 8.
The other matter is same.
Right.
Delay is same also.
Right.
Item number 9.
Item 9 and 10, I may permit to withdraw the double filing.
Double filing and therefore withdraw. Dismiss is withdrawn.
Item number 11.
11, my lord, DLR matter, 25th September.
25th September.
Item number 12.
At 12, my lord, your lordship has dismissed similar matters. I'm giving.
Should I give another copy, Your Lordship?
In view of the order passed with this court on 4/4/23 in writ appeal 1321 of 2022, bracket State of Odisha versus Vijay Ketan with the other Sahu, the present appeal is dismissed.
Only one prayer, Your Lordship. Because of the judgment, there is no time limit, and the order has been passed in the way of August 2022. Let them comply within a period of as with this honorable court.
File contempt there. Two matters said that to
both are dismissed. Correct.
Great.
Item number 13. Item 13.
None appears dismissed.
Item number 14.
13 promotion during pendency of vigilance case, your lordship is fixing to 11th May.
11th May. All right.
Item number 15.
My lord, item number 15 after vacation.
Sorry?
After vacation. Time may be permitted.
I see. All right. List on 31st July, defects be cured.
Item 16.
None appears dismissed.
Item number 17.
My lord, permitted to return.
Dismisses, withdraw.
Then note 18.
The order allowing the review, your lordship, is the subject matter here. In page 75 is the order impugned. My lord, initially the facts are like this. In a surface proceeding pursuant to this, your lordship's direction in a repetition, I deposited 1 crore 15 lakhs with the bank. Subsequently, the bank transferred the entire assets to the reconstruction company, your lordship. 6 months thereafter, that was sometimes in 2013. After properties were transferred to this Pegasus, the reconstruction company, I negotiated with it. They wanted the balance amount. The bank did not transfer the balance amount. We told that 1 crore to 15 lakhs, it kept with it. I separately settled the account with the financer. I approached the bank saying, you return the amount with interest. That didn't do. I came before your lordship in a writ petition in single bench, and that court allowed that you return the amount that is at page page 66, your lordship. Opposite part number 1 will forthwith release the amount in no lien account along with accrued interest to the opposite party. Number 3, that is the reconstruction company. The money must be transferred such and such. Now the bank comes up with a review saying we had kept the amount in a low lien account and which did not carry any interest. Your lordship would possibly agree there is nothing called no lien account. An account is there where lien is marked. Account is an account. Money is kept in a bank. Either it fetches
Current account or savings account.
Any account.
Current account don't earn interest.
Current account don't earn interest, but nobody said you keep it in the current account. We demanded the money in 2016. We demanded in 2017. After transferring the assets in favor of a reconstruction company, my lord, beyond that it becomes illegal at their end.
No, but if no interest has accrued, then how can they pay you?
No, bank has utilized my funds as far as CRA is concerned. Your lordship visualize.
Kept in it? No. Simple thing is, was it kept in an interest-bearing account?
That we don't know, my lord.
No. So once they say there was no interest-bearing account in which it was kept, then unless you prove to the contrary, how can you get it?
Yeah, that is what I submitted with the court below, honorable single judge. I said, my lord, I made a demand in 2016. You neither did return the amount to me, nor to the reconstruction company. So beyond demand date, withholding the said amount, you have to compensate me.
The expression uses accrued interest. See, there are sometimes when we say pay this amount together with interest. As the court, you say
your lordship's order in the division bench was not in to keep it in any account. They said subject to deposit of 1 crore 30 lakhs. No further action will be taken. I deposited the amount. I demanded it back because you
have insisted even then that the court should order it being kept in a fixed deposit, which is what we do.
Yes, that is not there.
If it is not there, then the amount is not earned interest. If it is not earned interest, how can you say pay it together with accrued interest? No interest accrued.
Your lordship knows the bank uses these funds in different ways.
That's different. That's why you then ask the court to say, while they pay me this amount, they should also pay simple interest or compound interest or whatever. Then the court separately orders that. You didn't ask the court to do it.
I said accrued interest.
No. Accrued is presuming that it's in an
it is earning interest. Now, my lord, I demanded the money. Once they didn't pay the amount either to me or to the reconstruction company, how can they hold it, my lord, beyond that? Your lordship, there is no reply to this in my demand in the writ petition regarding payment of interest. There is no reply to it. They never said in the counter affidavit that we had not kept it in a interest-bearing account.
No, it's the other way around, sir. Unless they say it's an interest-bearing account, you can't presume that it will be an interest-bearing.
And your lordship may look at from another angle.
Yes.
This, as per this Successor Act, my lord, Section 5, entire assets and liabilities are to be transferred to the reconstruction company.
Right.
Now they transferred this portion, only the properties, not the amount which I had deposited. And I paid interest on the entire amount. They also asked for this, asked for the money. The reconstruction company also asked for the money along with interest. At least if it was not earning interest for that period, from the date of demand of interest, that should carry interest, my lord.
No, but the release of money prayer has been allowed. That prayer was allowed.
That prayer, no, I am not on that, my lord. What I am submitting, if your lordship says that this was not kept in an interest-bearing account, at least it can be assumed the day I made a demand for interest with refund, from that day they should pay the interest.
No.
That is the law as I understand, my lord.
It's not automatic.
Your lordship may look at page 50. That was a demand made by the reconstruction company on 21 to 2018.
Yes.
We therefore request you to please release the aforesaid amount 115 lakhs together with up-to-date interest. This is their demand. I have been demanding, and there is no whisper in the counter affidavit as well, that we have not kept it in a no-lien account, not an interest-bearing account.
So the problem is you said keep it in a no-lien account, but you didn't say keep it in an interest-bearing account. Or should have simply said keep it in a fixed deposit. That would have been the best.
My saying won't help, Your Lordship.
Why not?
My saying won't help.
At least there you can say the bank was aware that you wanted interest.
But at least since the date of demand, if that initial, if Your Lordship.
It's not automatic, sir. This is the whole problem. It's not automatic.
No, that will send a very wrong signal, Your Lordship.
So what is wrong
keeping
signal?
going
It's
to
happening day in and day out. You see the orders that we pass, we say if you the day you make the deposit, it will be kept in a fixed deposit.
I can't.
Then you can say interest accrued thereon.
I can't. We can't force the court to do it. But
Not
this
force. You normally make that request. Let the money not be,
Now Your
idle.
Lordship.
Let it be in an interest-bearing account.
Now Your Lordship.
Most courts pass that order on council.
Now, these days that is being done. On those days, Your Lordship, those things were not done then, my Lord. Your Lordship, the interim order was, as an interim measure, it is directed that no coercive measure shall be taken against the petitioner pursuant to the notice such and such, subject to condition shall deposit a sum of 1 crore 30 lakhs. This was the direction.
Yes.
So pursuant to this direction, the amount was deposited.
Correct.
And my demand, they did not reply to my demand also, Your Lordship. In the writ petition, I said, may I take Your Lordship to the assignment agreement?
Yes.
Page 24. (2.1.2).
Yes.
The assigner hereby further assigns in favor of the assignee, that is that construction company, and the assigner is the bank, my lord, all its right, title, and interest in the financing documents, all agreements, deeds, and documents related thereto, and all collateral and underlying security interest and or places created to secure and to guarantee issued in respect of the repayment of the loans which the assigner is entitled to. This not having done, having not transferred this amount, they cannot, holding that amount beyond this date of transfer, possibly, my lord, either me or the reconstruction company, either of us is entitled to interest on this because you have been demanding. And that next page, page 25, 2.2.1, any payment by the borrower on or behalf of the borrower in discharge of the loans to the assignee into the collection payout into the hands of the duly authorized agent of the assignee shall constitute a discharge of the obligation of the borrower to the assigner and assignee to make such payments. So that amount could have been reduced by this.
No.
And I have been paying interest.
The present appeal is directed against an order dated 1st February 2023, passed by the single judge, allowing review petition number 34 of 2022, filed by the Allahabad Bank, bracket now Indian Bank, bracket, seeking a modification of a direction contained in para 4 of an order dated 9th February 2022 in WP Civil 2797 of 2013, requiring payment of rupees 1.15 crores that had been deposited by the petitioners, together with single quotes accrued interest, unquote, paragraph. It appears that an interim order was passed on 12th March 2013 in writ petition civil number 2797 of 2013, which read as under, take the whole of page 78, whole of para 6 and page 78. Paragraph. Soon thereafter, on 13th April 2013, the petitioner addressed a letter to the bank depositing the aforementioned sum and stating the quotation from the bottom of page 78. Paragraph. on 17th March 2021. Sorry. No, on 9th February 2022, the prayer for release of the money was allowed together with single quotes accrued interest, unquote. The review petition was filed by the bank, pointing out that the money did not have any, the money asked to be refunded did not earn any, open quotation, accrued interest, unquote. And therefore, that portion of the order required to be modified. Paragraph. Mr. Sarangil and senior counsel for the petitioner argued that the bank would have earned interest on the monies deposited with it by the petitioner. And therefore, even if the sum so deposited had not been actually placed in a fixed deposit or an interest-bearing account, interest would nevertheless be payable thereon. Paragraph. The court is unable to agree with the above submission. Full stop. Unless there was a direction that the amount deposited by the present petitioner should be kept in fixed deposit or an interest-bearing account. No liability can be fastened on the opposite party bank to pay interest on the amount so deposited at the time of the refund of the amount. Paragraph. There cannot be any presumption regarding payment of interest. It has to be specifically directed to be paid or to be kept in a fixed deposit or an interest-bearing account. Paragraph. Consequently, the court is unable to find any grounds to interfere with the impugned order. The writ appeal is dismissed.
My alternative prayer, my lord, may kindly be that from the date of demand at least.
Yeah. Alternately, is prayed that at least from the date of the demand, interest should become payable. The court is again unable to agree with the above submission.
Item number 19.
May I please your lordship? Here, my lord, the petitioner is a society. The name of the society is Policry. My lord, the said society is manufacturing the different school materials with help of some economical weaker people, my lord. And the said society has obtained a the said society took a one shop room from PDDRDA department under the Swarna Jayanti Grama Swarojgar Yojana, my lord. So now when the said society is continuing his shop room on the shop which has been given by the PDDRDA department, at that time PDDRDA department has initiated a case, criminal case against the present.
Where is the impugned order, sir?
My lord, that is annexure 11, my lord.
Page
41, my lord. My humble submission before your lordships, my lord.
41 is an order of the collector.
No, single judge order.
Sorry, my lord, sorry. 43, my lord. 43, page 43, annexure 12, running page 45. My lord, only the application was, sorry, my lord, the writ application was rejected on the ground that I am doing my business unauthorizedly, my lord, because when there is a agreement for 3 years, my lord, so now the agreement is no, when there is no agreement, so I am doing my business unauthorizedly, my lord. My humble submission before your lordships, my lord, if your lordships kindly see, my lord.
No, not unauthorizedly. There's nothing to show renewal of the agreement.
My lord, there is.
He is.
Unless there's renewal of agreement, there's
my lord, if your lordships kindly see.
Last date, your lordship has directed me to get instruction whether there is any possibility of settlement. I have filed my counter affidavit that there is no possibility because he is continuing unauthorizedly. There is no renewal of agreement since long, and both 2 times he had approached the court and honorable court has rejected his claim. No. And he is trying to forcibly occupy the shop room which we want to renovate and give it to. He may be a allottee after this under the new scheme. But
you say pursuant to the order dated March 2023, it is informed by Mr. Devakanta Manthi, learned additional government advocate, that there is no possibility of legalizing the present arrangement under which the appellant has occupied unauthorizedly government a property belonging to the
PDDRDA department.
Government.
Government, DRDA is government.
The term of the agreement expired in 2010
In
itself,
2010.
and thereafter there was no renewal of the arrangement.
May I pardon, my lord?
For the last 12 years, the appellant has not vacated the room, and this prompted the proceedings being initiated against him by the sub-collector by an order dated 16th December 2022. Paragraph. Yes.
May I pardon, my lord? Here, my lord, my humble submission before lordships, when there is a point of law, my lord, on the ground that this shop room is not a public premises. If your lordships kindly see the Odisha Public Premises Eviction of Unauthorized Occupation Act, my lord, Occupant Act 1972, my lord, as per the section 2 subsection F, my lord. Public premises means any premises situated within the jurisdiction of a municipality or within an area declared by the state government to be an industrial estate and belong to or taken on lease by the state government or the board or by any company, corporation, municipality, improvement trust, special planning authority or university or requisition by the state government, my lord. Here, my lord, the said public premises, it is not coming under the public premises, my lord, because
It is within Bhadrak municipality area.
No. This is not a Bhadrak municipality area, my lord. If your lordships kindly see the order of the
Did you take this plea before the single judge?
Sorry.
Did you take this plea before the single judge?
My lord, though I have taken, my lord, kindly see, I have taken such plea before the honorable single judge in my writ application, my lord. If your lordships, my lord, kindly see the decision of division bench of our own honorable High Court, my lord.
First, did you take such a plea is the question, sir.
On the ground of equity, the honorable single judge that you are unauthorizedly occupying for last 13 years without any agreement.
No, I have also I have also paid the rent amount, my lord, that I have.
That's right. Yeah.
My lord, kindly see in my writ application.
All right. The present appeal is directed against an order dated 17 February 2020 passed by the single judge dismissing WP Civil 4716 of 2023 filed by the present appellant, challenging an order dated 20 January 2023 passed by the collector Bhadrak in OPP appeal case number 2 of 2023, thereby confirming the order.
My lord, in my paragraph 15, my lord,
passed by the SDJM.
SDJM. Not
SDM Bhadrak in criminal case number 4 of 2022. Paragraph.
My lord, in my writ application 15, my lord, paragraph 15.
All right. SDJM, everywhere it's typed as SDJM.
That is typography. That is subdivisional magistrate.
Or
SDJM is judicial side.
Correct. the premises in question was a shop. In a market complex situated in village Samaraipur under Bhadrak municipality area.
No, my lord, this is not a coming under the Bhadrak municipality. They have wrongly mentioned that it is coming under the Bhadrak municipality. It is village Samaraipur, my lord. The collector has also mentioned in that order also. This is coming under the Bhadrak municipality, my lord. Only I am placing only that point. When there is a specific provision, my lord. So OPP Act is not applicable. And on that ground, I have filed this the judgment of this.
The admitted position is that the term of allotment was long over, and the appellant continued to be in occupation of the shop room in question. The agreement had not been renewed. In the circumstances, the court is unable to find any legality committed by the authorities in instituting the eviction proceedings and thereafter directing eviction of the appellant from the premises in question. Additionally, the counsel of the appellant has been unable to point out any error committed by the non-single judge in the impugned order, which calls for interference. The appeal is accordingly dismissed.
My lord, can I pray for time maybe targeted maybe?
Sorry.
It is some economical weaker people as doing their.
Oh, he is taking some time to vacate. That will not save. Within 1 month, he will
subject to the nevertheless
within 2 months, my lord.
Appellant. The one appellant or several appellants?
One, my
one.
Appellant filing an affidavit in this court with not later than 15th May 2023, undertaking to vacate the premises and hand over peaceful possession thereof to the opposite parties. Not later than 31st July 2023. The petitioner, the appellant will not be evicted from the said premises till then. Full stop. It is made clear that if no such undertaking, if no such affidavit of undertaking is filed within the time stipulated, this interim protection will not survive.
Oh, bless.
All right.
Item number 20.
May I please, yours. This is a matter relating to regularization of the contractual employees of the driver. And identical matters are 25/9.
Correct.
Item 21.
This is a matter relating to squarely covered by the Patita Bhavan Datta's case matter, that is W
number of the judgment in Patita Bhavan Panda. This present writ appeal is dismissed.
Item 22.
This is a matter relating to ad hoc promotion pending vigilance case, and identical matters are posted on
11th May.
Item 23.
23, my lord. This is a matter relating to pension of the Varsage employees. But that is 14/9, my lord, identical matters.
Item 24.
24 old pension, 25th September.
All right.
Item 25.
25th, my lord. It is fixed to 2nd August.
All right, same order.
Item 26.
14th September, my purchase.
So all 26, 27, 28.
26, 27.
All right.
Item 28.
This is also my lord Varsage. 14/9, my lord. 28, my lord. Pension of Varsage employees, my lord. 14/9.
Item 29.
29.
My lord, this is a matter relating to recovery proceeding, my lord. Herein, I got some instruction, my lord, that some identical cases have been disposed of. So I will take some instruction in this regard, my lord. This may be taken up
Pass over then.
Some other day, my lord. Next week, my lord, this may be taken.
All right. The request to cancel the appellant list on 16th May.
Most of them.
Item number 30.
30 my Sarta Parade matter that your lordship disputed yesterday. That is college.
Same as yesterday. Right. In view of the order passed yesterday's date, in writ appeal so and so, the present writ appeal is disposed of in the same terms.
Right. Item 31.
31, my lord. In item 31, your lordship has directed that within a particular date, the counter will be filed, otherwise 25,000 rupees cost. But today I have filed a counter appeal with the IA to recall that order because within time I have not filed. The reason I have mentioned that we have issued the letter, but
where is the counter?
Yes, counter is there.
All right. Today, counter affidavit is handed over on behalf of opposite party number 5, which has been provided to counsel for the petitioner who is permitted to file rejoinder thereto for the next date. In IA number, for reasons stated therein, the application is disposed of, waiving the requirement of the applicant state government to pay costs. That list on.
Sorry.
7th August.
That your lordship has recalled that. Obliged.
Item 32.
Let the petitioner in this case challenge the next on 9, 10, 14 and 15. The question is for running clinic or hospital, a fire safety certificate is necessary. These rules came into force in 2017 and there was an amendment in 2019. So as per the amending rules, Milord, if any hospital is constructed, so subsequent to the amending rules, Milord, it requires a fire safety certificate. Since the hospital of the petitioner was continuing since 2009.
Anyway, list for final hearing on 31st July.
There is a case pending, similar letter 1365 of 2016. It may
along
be
with
tagged
1365 2016. All right. Interim order to continue.
Milord, obliged.
Item number 33.
So the matter has become infructuous.
All right. Disposed of is infructuous. All right.
Item 34.
Hello. Hello.
None.
Hello. Hello.
Item 34.
Hello.
Item number 34.
Yes.
Yes, sir. Proceed. You're muted, sir.
Hello.
Yes, continue.
Further affidavit filed by OP number 3, copy of which has been received at this end by me in the last occasion. I am supposed to file the rejoinder. While going through the affidavit, it is seen that it is just a repetition of the previous affidavit.
No. It's not a repetition. We have stated something more.
I have gone through the affidavit for filing rejoinder. The previous affidavit, previous counter affidavit has been filed by Commissioner of Endowment, Mr. Datta, and this has been filed by the then Commissioner Endowment. Simply that is there. And as far as I have received the copy,
by WhatsApp and found paragraph para 1 is the para 2 of the previous affidavit, para 2 is para 3 of the previous affidavit, and para 4 is the para 6 of the previous affidavit.
If you do not wish to file rejoinder, say so. We'll just record it.
Okay, sir.
Petitioner appearing person says that he does not wish to file any rejoinder to the additional affidavit filed by the Commissioner of Endowments.
The contents of it is same is
all right.
And another affidavit has been filed on 10th March 2023 by the former IIC Golanthara PS.
That's what he says. He doesn't want to file it.
Okay. No, I have not received the copy of this one.
Have you given a copy?
Come to receive.
Sir, I have not received copy of this one. Affidavit of
He is staying in Barampur. How can I serve copy on him?
You send your email, sir.
Yes.
Copy of the affidavit filed by the ex-IIC Golanthara police station is served.
Mr. Alok Kumar Jena.
Be served on the petitioner who appears in person through his email, which he will provide to counsel for the state. Today itself. List on. July 27, sir. Continue after lunch.
Item number 35.
If I pray any other day, Your Lordship, because I have instructed to appear, I have received the Bhakultrama in this case, my lord, today morning itself.
For whom? For petitioner?
Petitioner, my lord. Brief has been transferred, my lord.
No, but what is the matter about one? Construction of Kalyan Mandap.
I have received the Bhakultrama from the petitioner, my lord, today morning. Has Your Lordship desired any other day, Your Lordship? Or is, once I appear, my name will be also reflected, Your Lordship.
The BDO has shown the affidavit in 2019 that the work has already been started.
And 6.5 lakhs has already been spent.
6.5 lakhs has already been spent.
Lordship might come tomorrow, day after tomorrow, for which I can be prepared, my lord.
We are just see how we are preparing now.
Lordship.
Yes. For you, it's much easier, sir. You're much smarter than the two of us. You start reading, you'll know it in no time. Just pick up that reply affidavit.
Lordship, then the passover.
No, just pick it up. Just see that reply affidavit. Come. See para 5.
Para 5 of the Lordship.
The BDO was filed an affidavit.
BDO affidavit. Page code.
I need some preparation on with regards to the para 5, Your Lordship, that the BDO has answered that that is finalized in the Gram Sabha, my lord. But when there is some other land, my lord, and this is Kisham is something different, my lord, and the alternative proposal is given.
School is closed down, sir. You are trying to say this is a school playground. The school is closed.
The school is non-functional. That is the
then the whole purpose goes.
Lordship,
the school itself is not functional.
That is the main ground taken in DPI.
Lordship, this matter may be kept tomorrow, my lord. Tomorrow, my lord. After tomorrow, because
we are not free tomorrow. For us, it's problematic.
Lordship, I am the petitioner, my lord, but I am now I have today morning I have received the Bhakultrama on behalf of the petitioner, my lord. Lordship, I pray tomorrow because I will be prejudiced, my lord. Petitioner will be prejudiced.
We have prejudice if it's tomorrow. Lordship, we are not free.
I must put some points on behalf of petitioner, my lord. Because either Your Lordship pass over it up or Lordship keep it tomorrow, my lord.
You are waiting since morning, sir. This matter could have normally come at 10:35. You're waiting, listening to the whole elephant corridor matter, or you're not? You were. So, enough time. See, we've all been at the bar. Waiting for a matter, you quickly go through a matter, particularly if it is before a bench. who doesn't grant adjournment easily. So you start preparing.
I know that also your lordship is
We are one such bench.
I know your
Very
lordship is
stingy,
sometimes so
very
kind-hearted
stingy in
your
granting
lordship.
adjournments.
Because once because I suppose I cannot give some points before your lordship, which is very much essential. Then the petitioner will be prejudiced. For my default, my lord, petitioner should not be suffer, my lord. Therefore, tomorrow.
This is classic dialogue.
No, lordship, that your
He's
lordship.
already suffering because you did not prepare for morning.
No, tomorrow, today morning I got the, then tomorrow morning, lordship, I just pray.
Okay, we'll give you two options.
Lordship.
We'll give you two options. Adjournment plus vacation of stay. All right. We'll give you whichever date you want, but stay will be vacated.
Lordship,
no problem.
Tomorrow it will be finished.
So if you're not ready to argue today, stay will be vacated. All right.
Then
if you want stay to continue, then you better argue today.
Then let's pass over it.
That option also.
Last matter,
that also we are not giving you.
I want to go some points, lordship.
Pass over already happened for 2.5 hours in the morning. From 10:30 to 12:30 only pass over.
I need some minutes to look into the papers, your lordship.
We have just 2 minutes. Shall I tell you what the point is? How many minutes have I read it?
Therefore,
I read it only for 2 minutes. I'll tell you what the point is. You want to know what the point is?
Lordship, just 1-2 matter pass over, your lordship.
Tell me what the point is.
At least I must have gone through the paper, lordship.
All right. You see, there is a stay.
Lordship, one pass over, lordship.
There is a stay granted in this matter since 21st January 2019 on the continuation of the construction of a Kalyana Mandap on a plot number 162 of village Pachupadi in district Khorda, with the petitioner contending that it was a school playground. Paragraph. In the reply filed by the Block Development Officer, bracket BDO, it is pointed out that this was a 35 lakh project under the FSF scheme for creation of capital assets of the Panchupalli Gram Panchayat, bracket GB, for revenue generation, and was technically sanctioned by the Additional Project Director, DRDA Khurda, on 10th May 2018 itself. Stop. Although the kism of the land was single courts playground, it was evident from the report of the Revenue Inspector, Kudiyari, that the school was no longer functioning as it was closed down since long. In other words, there is no school existing over plot number 162 or even near plot 162. Paragraph. Further, the school in question was earlier established over plot 173, Hata number 406, more than 200 meters away. Whereas plot number 162 was supposed to be the playground for the school. Stop. With the school itself having closed down, the question of depriving children studying therein of the playground did not even arise. Even the temple was more than 100 meters away, facing the road towards north, whereas the Kalyana Mandap was going to face towards east. Paragraph. A rejoinder was filed by the petitioner, now contending that guidelines of 13 July 2017, which required tendering for project exceeding rupees 5 lakhs, was not followed. In the reply filed to the rejoinder, it is pointed out that the said guidelines did not supersede the earlier guidelines dated 2nd July 2015 regarding creating of capital assets under revenue generation head. Full stop. It is pointed out that for such projects which are revenue generating, no tender was required even if it was more than 5 lakhs. Paragraph. It transpires, therefore, that the factual position on the ground with that is no school functioning in the area in question has removed the justification for any interim order to continue. Stop. Accordingly, while vacating the stay order passed with this court on 21st January 2019, this court notes that with already rupees 6.5 lakhs having been spent on the construction of the Kalyan Mandap, the said construction should now proceed in accordance with law. Paragraph. Counsel for the petitioner states that he is not prepared to argue the petition today and seeks an adjournment list on 9th October.
Lordship, one thing, Lordship, may direct the subject to result of the writ application, my lord. Outcome of the subject to result of the writ application, Lordship.
Who's in 36?
35, Lordship, that aspect, Lordship. Otherwise, the matter will be infructuous, Lordship. Subject result of the outcome of the writ application.
In 36, you're in 36. Ah. What is it about?
36 already received the counter affidavit. I have taken instruction to the effect that the part compliance so far mentioned in the counter of the affidavit manner that is admitted. They have already complied. So far the installation of the school as well as the DT place of DT that has not yet been decided. I have just received a para-wise comment. Let me file the rejoinder. Lots of
already 2 adjournments granted since October, sir.
For rejoinder, he has taken.
Can't be adjourning for 5 months, 6 months for rejoinder. So despite 2 adjournments, no rejoinder has yet been filed. So the request for further time for rejoinder is hereby refused. So it is seen from the counter affidavit filed that rehabilitation assistance benefits have been paid to the original 3879 displaced families. And 91% of the total sanctioned amount of rupees 224.64 crores has already been paid. Full stop. Further rehabilitation assistance amount of rupees 10.74 crores has been paid to 733 affected families, constituting 95% of the total earmarked funds. These families belong to 16 revenue villages under the Kanupur irrigation project, Basudevpur. The details of the other amounts dispersed to the displaced families have also been set out in the affidavit. $115 homesteadless displaced families were identified and were disbursed rupees 9.36 crores, constituting 73% of the total rehabilitation assistance for that purpose. Further, it appears that a similar issue is now sub judice before the National Commission for Scheduled Tribes, Delhi. Where action taken reports are being filed. In view of the elaborate counter affidavit filed, stating out the above facts, and with no rejoinder having been filed till date, the court proceeds on the basis of the correctness of those averments. Full stop. The court considers it not necessary to pass any further directions in the matter. It will nevertheless be open to the government to continue to place the required details before the NCST, where a similar matter is stated to be pending. The petition is disposed of in the above terms.
One thing, my lord, so in addition, lordship may see that page 42, 43, 44 of their counter affidavit, they have admitted that certain under project constructions are there. So let it be completed, man.
That will be
meantime.
That we will complete. In 37, we have filed the counter affidavit, but we have yet to submit the copy to my learned sister who is appearing. Almost the pleadings are completed. Let me pray your lordship to keep it date for hearing, because soon on the date of reopening itself, the lordship can.
My lord, I have filed an intervention application that is not on board today.
Can it be before vacation, your lordship?
On the date of reopening, I pray.
Because the opposite party 5 whole matter is projected against him. It is in form of a interest litigation in the interest of public, but it is not a PIL, your lordship. There are suppression of fact. The tender was challenged before the sub-collector. It was rejected. Thereafter, it was brought before this honorable court. Again, it was rejected. Now it is in the form of PIL, your lordship. And I have deposited the bank guarantee and other expenses, your lordship. Till date, I have deposited 2,23,39,393 amount, your lordship. And I am
your intervention application. Give me a copy.
I've subbed a copy. I've already subbed a copy.
Let the matter come after reopening day.
Now the state is supporting the petitioner, is it?
My lord, I have also filed an interim application for implication of other bidders who have quoted higher price than the option opposite party number 5, my lords. My intervention, interim application number is 6.
No, we are not supporting anything. We have only placed the facts. It is your lordship to decide what. There is some dilemma with regard to the PIL petitioners are claiming that this much of amount should have been.
The petitioner was neither a bidder nor is he affected in any manner.
No, he is a PIL petitioner.
No, so he's not a bidder.
But his whole case is revolving around a single person, RJ Bharat Kumar, and his representation also says so. Whereas RJ Bharat Kumar has instituted 2 cases against the opposite party number 5.
What happened to the writ petition 31066?
It was rejected, your lordship. I have
I see. Then why should we deal with this as a PIL? That's already been tested. My lord, it's already been tested. You see, it appears that the present petition
That
projected as a public
petition perhaps
notification
by the bidders.
involves interests of private parties who were bidders for a Sand Sairat lease. Full stop. An unsuccessful bidder had already filed WP Civil 31066 of 2022, which was disposed of by this court on 22nd December 2022, not accepting the plea of the said petitioner, thereby affirming the award of the bid to opposite party number 5. Full stop. That order has already become final. Full stop. Therefore, there's no occasion for the court to again entertain a separate PIL, which questions the very same grant of lease in favor of opposite party number 5. Full stop. In that view of the matter, the court is not inclined to entertain the present petition. The interim order is vacated, the petition is dismissed.
My lord, my submission is that, my lord, I'm one of the interveners, my lord.
Intervention is all out of question, sir. In that intervention, say for the reasons stated above, none of these intervention applications can be entertained and are dismissed. Yes.
May I please, Your Lordship, madam?
Yes.
Here, by order dated 9/3/2023, the issue is with regard to whether the appellant belongs to the Anganwadi center area or not. By order dated 9/3/2023, Your Lordship was pleased to direct the state to file an affidavit. They have filed an affidavit on 2/5/2023. Paragraph 3, they say that I do not belong to the central area. My lord, I believe that at this appellate stage, it will be difficult to disclose that finding. Your Lordship, in this.
All right. An affidavit is being filed by the Child Development Project Officer, Cuttack City /2 District, stating inter alia that the appellant does not belong to the Vidyapur Nuwasahi Anganwadi Center. Of this being a factual position, the case of the appellant is therefore not made out. The appeal is accordingly dismissed.
Obliged.
This is a Anganwadi recruitment matter, my lord. Page 18, my lord, kindly see the responsible officer to that to appellate authority, what the order he has passed, and I have quoted in page 18, my lord. There is a comparison between a lower grade and higher grade of fraud. My lord, kindly see from the above, it is clear that the appellant as well as the respondent number 4 allegedly to have filed forged documents for their engagement as Anganwadi worker. This court is not competent to examine the genuineness, my lord. So this is, they have chosen the higher grade of fraud. My lord, why I am saying he has committed fraud? And my lord, kindly see, Annexure 1 is the advertisement where 2007 has the recruitment has to be had to be conducted. In 2010 only, he applied for mark sheet and got that mark sheet in year 2010, my lord. Kindly see that document under ACTA Act also I have annexed. And he has selected on basis of the forged mark sheet. Thereafter, after 3 years of his selection, he has given the Board of Secondary Education mark sheet, which is supplied to him in 2010 after 3 years. Page 34, my lord, kindly see. Page 34, Board of Secondary Education Orissa, mark sheet supplied to him on 25/1/2010.
But the impugned order goes on a very different footing.
Yes, that's my case, my lord. The honorable single judge was not dealt with this fraud accept of this case, my lord. That is my case before your lordship. That has never been gone into, and they have the records.
He's examined some Thakur Patna and Tali Patna.
That's my lord. My lord, kindly see the appellate authority order I have read out. He said that both of them, me, the petitioner, and the respondent number 4, who are selected, used forged documents. So there is a comparison between a lower level or higher level of forged documents. What is, I have.
Who's appearing for respondent number 5?
Yes, I am.
All right.
Yes, so far as mark sheet is concerned, my lord, the respondent secured higher mark than the appellant, my lord. The authority duly verified the documents and accordingly gave the appointment, my lord. Appellant respondent is serving since 2007, my lord. Authority CDPO OP number 2, my lord, duly verified the document, accordingly gave appointment, my lord.
You're serving
Anyway,
since 2007.
My lord.
16 years now.
Yes.
2007 on the fraud, basis of fraud.
No.
I have got
Forgery.
that file,
Yes.
my lord. On last occasion, your lordship directed me to produce the original file.
Ah.
That file is with me.
Ah.
My,
She says there's some manipulation in the mark sheet.
what has happened, my lord, that in fact that mark sheet,
Ah.
I am giving that original file, your lord. See.
Respondent secured more marks, my lord.
No, we'll see who she says the mark sheet is forged. That's the whole point, sir.
Your lordship can find that I have given that. Your lordship may see page 63 of that first file. There is page 60, that is the application form of respondent number 7. There your lordship can find it from page 66.
Yes.
She has given that.
Correct.
Lordship got it, Mal.
Yes.
Page 66, that HSC certificate is there. There is a HSC certificate. That certificate is given by the school. That your lordship can find it there. That mark she has secured 446. But another certificate is there. Your lordship can find it from page 70. That certificate has been issued in the year 2010. That is in the file, madam. What has happened? Your lordship can find it from the backside of all the documents filed by that respondent number 7. She has signed up to those documents, page 69. But so far as 2010 certificate, in that certificate there is no signature. How that has come to that file, I don't know. But on the basis of that mark sheet, she has been selected.
So, but what's the difference? Same mark sheet.
Same mark sheet, but the only difference your lordship can find it that was issued in 2010, that page 70, your lordship can find the last signature. Your lordship.
That may be.
Yes, but there is no further in that mark sheet. Mark is same. Mark is same, but that was issued in the year 2010.
So, but why is she saying it's forged?
So mark, my lord, may I clarify? Mark is not actually same, my lord. My lord, kindly see page 32. That is the RTI document they have given. She was selected on basis of as if she was secured 528, my lord. When we have filed appeal, my lord, page 32 last, that is interpolated and that is being overwritten 446 thereafter. First, it was on 528, my lord. That is another document is there. I will show to your lordship, my lord, 446. Then he has replaced all the documents. Then, my lord, he got the Board of Secondary Education. He matched it according to that. In 2010 only, the mark sheet is provided by the Board of Secondary Education.
No. I can understand if earlier she had got less marks and the replaced has more marks.
Yes, he has more marks, 528. He got selected on basis of 528. My lord, that is page 32. My lord, can you see the last one?
No. Where are the minutes of the selection committee that will tell us?
That they have chosen what to give or not, what to hide.
Everything you can't doubt. So the selection
is always there. He is the wife of Sarpanch.
My mark is 446, my lord. Anyway, I have secured more marks.
Not anything. Fraud is fraud.
No fraud, my lord. That is not in the record in the government file, my lord. Where they have got.
I am giving, my lord, another file.
Computer generated mark sheet.
Computer generated, no, my lord, that's at that point of time. So these, I am giving another file that you can find it.
Headmaster giving the mark sheet. My lord, in matriculation, always Board of Secondary. Headmaster has no power to give any mark sheet.
Yes. Unless you can find it that
class.
There's a correction there.
Yes, ma'am. You also can find it. Serial number 8 is respondent number 7, and serial number 11 is appellant. If 446 is taken into account, you also may see that serial number 8. It is respondent's mark, my lord. 446 mark. So it comes to, my lord, 62.3. Total she has secured 62.3. I also got it just right.
It is not a question of mark securing, my lord.
No,
It's not a merit. I am asking
Then you'll also turn to next column, serial number 11.
But there's no advantage. See, if she's taking advantage of a new mark sheet, then I can understand. She's not taking advantage because assuming what you say is right, the new mark sheet has lesser marks.
My lord, my submission before your lordship, that advertisement says you have to, last date of application is 21/5/2007. On the date of last application, my lord, she didn't have the mark sheet. Mark sheet in the matriculation only be issued by the Board of Secondary Education. That is issued in year 2010. That is under RTI Act, I got it. And where he has, first he has given 528. Then it is interpolated in 446. Anything they want, because headmaster is ready to help them. So on 528, he got selected. Then we have filed appeal. Then the ADM appellate authority stated both of you, the petitioner and the respondent, used for just forced certificate. After this finding, my lord, is this, my lord, legal that to continue in a post? What is that fraud? What is the genuineness of document? Is not it is the duty of the authority to find it out? My lord, it is a finding of the appellate authority. What is my forced? Let me know. And what she has forced, let
no, but anyway, you will not get it because there are others who scored more than you.
My lord, forgery is, my lord, kindly see that page 32. I will place my case, my lord. Forgery is, I am only on the side of, only on the submission of that, what fraud and how it is promoted by the authorities. My lord, page 32.
No. I'm just saying there is a Ranjita Bhuya. She has scored 414. So anyway, you will not make it. You want to see that? There is a Ranjita Bhuya.
My lord, that order, I will draw your lordship's kind attention to page 13, my lord. Last line of page 12. The appellant has alleged that the OP number 4 has submitted a forced mark sheet mentioning her total marks as 528. Although actually she has secured only 446 marks in HSC examination.
That is your case.
Yes, my lord, before the appellate authority. Secondly, the OP number 4 does not belong to that's another case. That's why, my lord, the appellate authority has given a finding, no prima facie documentary evidence. My lord, this is my first appeal. Then it was
No, let's understand.
My lord.
Your case was that she got only 446 marks.
My lord, she's got 446. That's my.
That is the document shows she's got 446.
That's how that has been done, my lord. I'm saying, what is the process? The process is more important than what is he secured. She secured, my lord, because he's the wife of the sarpanch. All records have been replaced, my lord. That is my first appeal case. Then my second appeal order.
I don't understand. You say she got 446 marks,
but that is not 6. She got selected on basis of 528. That is, my lord, page 18. My lord, kindly see page 18. Kindly for a moment, my lord. That's what the records they have placed on the RTI Act. I have got the records. What is the appellate authority finding?
No. Where did you get that 528 you were showing us?
My lord, that is
page
with the that he has given to me. That was in the
page 29.
My lord, that is page 32. My lord, kindly see. It was in the notice
page
board.
29. Please see page 29.
Page 29, my lord.
Where did you get this from?
My lord. That he first he has given that 528. Then when we complained and filed appeal, he replaced everything and he matched it up to 446.
No. This 528 mark sheet was given later, according to you, not on the
not on the first selection. Then after we have filed a appeal before the ADM that this is a forged document.
Which one? This 528?
528. He has never
Where
secured
do you say it's forged? I mean, how do you say it's forged?
My lord, because my lord, see page 32. That's why I am giving importance to page 32. My lord, kindly see. That has been caught. 528 has been written. That has been caught and interpolated 446. The RTI document, the selection process, the entire selection record has been interpolated in 446. This is RTI document.
No, what is the advantage? I'm still not able to understand.
My lord.
By showing a lesser mark, what is the advantage?
My lord, this is because
I can understand if somebody else was competing.
He will say from the fraud because my lord, he has not given the actual mark sheet at the time of selection. When she knew that
why a lesser mark? See,
everybody is less than her after the selection process. Everybody's mark is there, my lord. My lord, kindly see. And those that got higher marks, they are of out area, not in that center area. So when we got it from the Board of Secondary Education, her mark sheet, then he matched everything according to the mark sheet. Only we got the mark sheet under RTI Act, under Annex 10, my lord, page 34. Then he matched up everything according to that. My lord, this was issued on 25/1/2010 only. 2007 is the last date of application. So 2010, he has got, and this is the mark sheet from Board of Secondary Education, Orissa. And 2007 is the last date of application, 2007 year. Well, it is not that he selected or he got the more marks. It is the person's intention and is the fraud. Because he is the husband of the selected candidate, the Sarpanch, he could replace all the records. And that is the finding of the appellate authority. And he is saying that I also did forgery, used forgery documents. What is that? FIR should be filed against both of us. But it is not, my lord, that should be. But we can't, my lord, we can't go forgery.
I can't have a pointless exercise like this. Yes.
My lord, this is a fraud, and by fraud he is continuing. And what records they have submitted to that effect, my lord, it is not. But
what is this page 29? What is that document? Page 29 of the
I've seen that. Page 29 or page 28, my lord.
No, 29 is that computerized Board of Secondary Education provisional certificate.
Saying that this document was submitted earlier. Page 20, that this is the Rekharani Jana.
So what is your stand? What is this document?
That I have given that file, that our stand, I have given that original file, in that file, that document is not there.
He has replaced everything. Selected on basis of page 33 as per their case. Page 33, my lord, C. Damodar High School, and that has been issued by the headmaster. The Board of Secondary Education mark sheet issued by the headmaster of that school in 2006. On basis of that, she got selected. But Board of Secondary Education mark sheet has been in 2010 only. So he does not possess all the qualification or essential documents before the last date of application. That would be my submission, my lord. Because in 2010 only Board of Secondary Education issued the mark sheet, irrespective of what is the mark. Page 34 issued only to 25 January 2010. On basis of 2006, 1810, 2006, page 33, she got selected. And that was not, that is the matriculation mark sheet should be issued by the Board of Secondary Education. That was the advertisement, my lord. Headmaster has no authority to issue any mark sheet in matriculation. And I have taken a definite stand that due to he's a wife of a And for what the additional district magistrate given that finding only?
So your appeal itself was delayed by 4 years.
Yes. My lord?
Your appeal itself was delayed by 4 years.
Then it is on the this honorable court remitted back condoning the delay. Again, they have dismissed. My lord, fraud has no delay. Again, they have dismissed on that ground. Again, I approached. Then they have rejected, stating that both of us are done the fraud. Then, my lord, this honorable court, without entering into that point, my lord, disposed of. My submission, one point, my submission before your lordship, that everything I have obtained through RTA Act. And they have,
So
how
the
can
only the weak point of your case is you yourself say she got only 446 marks. Her certificates show that she got 446 marks. So there's no one else who's got more marks. You certainly don't have more marks.
But my lord, that headmaster has no authority. My lord, it is not a question of mark. It's a question of how you fair and selection process, my lord. The headmaster has no authority.
See, there is nothing to show that she submitted some other mark sheet.
My lord,
Page 29, I don't know where that has come from.
My lord, that page 29, they have given it in through RTA. Page 29, the first selection, my lord.
Where is the RTA?
Page 29, my lord. This is they have given through RTA to us.
No, but there must be a covering letter giving it to you by RTI. Where's that?
My lord, that is there, my lord.
Where?
My lord, Child Development Project Officers, ICDS has given us, after we have filed it, then they have given us that this is the RTA document.
When did they give it to you?
It is there, my lord. It is RTA document, my lord, that I have given. All the documents has been given to us under RTA Act. Then we have applied under the RTA Act to the Board of Secondary Education.
No, but where is all that, please? Where is that letter of the RTI? And
my lord, that's there. I'm going to a lot of money. That all the documents are given under the RTA Act, but it is somewhere else annexed, I think. My lord, that is under. But how can, my lord, they say that this has been given by the Board of Secondary Education? Board of Secondary Education has never given the mark sheet before 2010. So, a document, my lord, that we have all given.
Just see page 29 again.
My lord, that is page 52, but this is in Odia.
I think this is the
my lord, kindly see that application also annexed. He has
Pass the detailed order. We'll pass it.
Well, she has filled up the mark,
All right.
the form that she has secured 528,
All right.
but actually she has secured 446.
All right, we've taken that note. You see, the present appeal is directed against an order dated
If powerful can do this, my lord, then
9th February 2015, passed by the learned single judge, dismissing writ petition civil number 13250/2014 filed by the present appellate, thereby rejecting her challenge to an order dated 15 July 2014, passed by the Additional District Magistrate Kendrapada (ADM), dismissing her Anganwadi appeal number 8 of 2012, whereby she had questioned the selection of respondent number 5 as Anganwadi worker (AWW) of the Talapatna Thakurpatna Anganwadi Center (AWC) in Kendrapada district. Paragraph. There were two major grounds of challenge raised by the present appellant to the appointment of respondent number 5. Sorry, respondent number 7 as AWW. The first was that she did not belong to the AWC area of Talapatna. Stop. On this, neither the ADM nor the learned single judge agreed with the appellant. Full stop. It was found that the appellant herself was a resident of Thakurpatna and not Talipatna, which was the area of the AWC. Full stop. The second ground on which the challenge was raised was that respondent number 7 had manipulated her matriculation mark sheet. And her selection was initially made on the basis of a certificate that showed her as having secured 528 marks. Whereas the final selection record revealed that the mark shown for her was 446. Stop. It is claimed by the appellant that pursuant to an application made under the Right to Information Act, she obtained information about the original mark sheet, bracket, which according to the appellant was a forged one, bracket, showing her marks to be 528, formed the basis of the selection. Paragraph. The ADM dismissed the appeal on the ground of delay. Stating and on the aspect of the mark sheet simply stated that, open quotation, this court is not competent to examine the genuineness of the certificates submitted by both the parties, that is by the appellant as well as respondent number 4 at a belated stage. Unquote. The appeal itself is rejected on delay. Also, as far as the learned single judge is concerned, apart from merely noting that the respondent number 5 scored 446 marks, which was higher than the marks scored by the present appellant, bracket. (377). The writ petition was dismissed. Paragraph. Since this was the only other issue that required to be examined, this court by an order dated September 17th April 2019, called for the records of the case. Paragraph. Today, Mr. Kuntia, learned counsel appearing for the state, has produced the records, including the register maintained for the selection process. It does reveal that, as far as respondent 5 is concerned, a certificate dated 18/10/2006 issued by the headmaster of the Damodar High School, showing the marks secured by her as 446, form part of the application form submitted by her. Later, a certificate dated 25th January 2010 of the Board of Secondary Education, Odisha, Cuttack, again showing her marks to be 446, was enclosed. Was submitted to the committee. When was this selection done? How old is your client?
42 years. $42 years.
No.
47
He
years.
was
47.
39 in
47.
2014.
47.
47. Column number 8. Column 8, if you see.
Yes, Mala, I've seen that. You'll also can find it. Two applications have been filed. Page
So
28.
How did she get hold of that page 28 application? I'm wondering.
And another application she has also filed page 30.
That's what. So in page 28,
the mark is 528. I've seen that. But in page 30, you'll also can find it that is 446. And also you can find it from paragraph 9 of the read. Para 23, my lord, you'll also find it from the writ appeal. See, para 23 of that writ appeal, he has not submitted all those documents before the ADM. That you'll also see that Annexure 9 series where all the documents, you'll also can find it from Annexure 9 series. The documents does not include that mark sheet and others.
No, this documented page 50.
Yes, my lord. That is the application of that Sumitra Sahu appellant.
Oh, appellant, is it?
Yes, my lord. It starts from page 50. The lordship can find it that next page, the document board certificate of that respondent number 7. That is second division. That documents that there is no such document, all these mark sheet and others, my lord. The voter list and other documents are there.
We only have getting second division.
Yes, madam. That second division 446 comes within the second division. 450 above the third division. This document is genuine document. There is no allegation about this document.
Okay, which shows her as getting second division.
Yes, but that is the admitted fact because 446 he has secured 446 mark.
The problem is past phase of RTI document, they are giving 5 to 8. Everything is correct, and she also filled up 5 to 8. That is the first phase of RTI document. I have come before this honorable court. This is my 4th round, my lord. Then second, when everything has come out, then they have matched up all the documents as if her husband is a powerful man. So everything is got. My lord, kindly say page 29 what my that 446 he has written, but it is in cut. That is interpreted 5 to 8, that has been overwritten, and 446. Then in RTI document selection process also this has been done. In page, my lord, that is 446. They have
no, that she's got a second division is clear. Because as he's pointing out, the certificate shows that she got second division, that Board of Secondary Education.
Marksheet, I am on Marksheet, my lord.
Let's see page 51. That is the second division.
Second division. But in the selection process,
that on the basis of a forged mark certificate, respondent 7 had had managed to get selected. So the precise case is that at the time of submitting the application form, she submitted a mark sheet showing her marks to be 528, whereas she had in fact secured only 446 marks, as was disclosed to the appellant by a letter dated 12th March 2013 or 3. What is that date? 12th March 2013 by the Board of Secondary Education, Odisha. Paragraph. The original file reveals that although there is some interpolation as regards the marks secured, in the sense that what number was originally filled up has been scratched out, and the number filled up in column 8 is 446 in the application form of respondent 7. She definitely enclosed the certificate of the Board of Secondary Education, showing that she secured the second division. Full stop. This is accompanied by the school certificate, certificate issued by the headmaster of the school, again showing her marks to be 446.
446 is the first class.
No.
446 second division.
62%, my lord. He selected on basis of 62%.
62, it had me, don't confuse.
Yes.
62.
Paragraph. In other words, the original record shows the mark certificate as 446. Stop. Paragraph. As far as the appellant is concerned, there is no dispute that she scored less than 446 marks. In other words, she scored only 377 marks. Stop. Therefore, there's no question of the appellant succeeding in the litigation and replacing respondent number 7. Full stop. Admittedly, it is respondent number 7 who, even on the basis of 446 marks, is placed higher in the order of merit than the appellant. Full stop. Since the selection itself was based on the basis was made on the basis of the appellant of respondent number 7 scoring 446 marks and not 528 marks. It cannot be said that she secured a selection through single quotes manipulation. Unquote. Paragraph. Consequently, the court finds no merit to the present appeal, and it's dismissed. The original files have been returned to Council of the State.
Mr. Rao has gone his surgery, my lords. That's why I pray to maybe taken up after vacation, my lords.
Who's undergone surgery? The respondent. Who's for the appellant?
For the respondent, my lord.
Who's for the appellant?
Appellants, I have already informed Mr. Sarang, my lords.
He has undergone a heart surgery, he said.
What is the matter about?
a retired state financial corporation employee, my lord, the rules do not permit for passing any after superannuation or lordship, there is no provision to continue the departmental proceeding, yet the board of directors, they have passed an order. That was subject one of the challenges in the writ petition.
Yeah, the conditions for acceptance of the voluntary
yes, my lord,
scheme is that you can't continue this writ petition.
No, I said I won't withdraw.
That is one of the conditions, sir, for the VSS.
So, no,
you
I
have
said
accepted two conditions. You've accepted the VSS amount, but you're not withdrawing the writ petition.
It's not a question of acceptance, my lord. After that, they passed an order that is at page 62, which they are not entitled, they're supposed to do, page 63. 62, it starts at 62. And the operating portion your lordship would find, yes, it is 62 itself, to treat the period of suspension as such to recover the amount of 13,000 something to withhold the ex gratia amount. Now, law doesn't permit, why I say, my lord, relying on the judgment 99 Supreme Court 1841, by September 2000, this year, my lord, September 2005, I had retired. Now, this order is being passed on 26/12/2005. The rules do not permit for continuation of a proceeding after a superannuation, my lord.
No. I think all that the single judge said was, if you want to challenge the continuation of disciplinary proceedings, you have to pay back the VSS amount.
That is not dependent on this, my lord. After this amount, this order came to be passed, whether that is legal or not. That is your lordship. I have come before the lordship because when the VSS was offered to me, even then my writ petition was pending.
Correct.
For that, your lordship has to look at the writ petition, my lord.
No. So come to that 24/10/2005. So this writ petition was filed in 1999. Correct.
99.
Now this offer was being made to you on 24th October 2005. Under the VRS VSS.
Yes,
right?
lordship.
Now you accepted that letter. There was no compulsion on you.
There were three conditions rightly held, my lord. Your lordship is right.
Correct.
What I said at page 57, my lord, the writ petition, if your lordship will look at annexure 14, there is no provision under the OSF to continue, and therefore, my lord, I am placing it. In your letter, you had put a condition that eligible grace. I am not keeping that, my lord. I am glad that you have accepted my offer, but have put a condition which is outside the purview of the scheme, and as such, only condition acceptance in legal parlance under the said is accepted, the same is not binding.
No. Did you accept this VSS or not? We paid any amount is a question.
They paid me the amount.
No. After you wrote this letter, why did you accept that amount?
Under pretext on the protest leadership.
How can it be under protest, sir? There's no question of protest.
That is, my lord, by then what they have done is.
Where have you said you are accepting under protest?
My lord. In the morning, he said that he'll be taking time. I've lost track of it. That is at page 58, my lord. I accept the conditional acceptance. There cannot be a valid discharge of relation with the corporation.
No, I don't understand. It's made clear to you that you had to withdraw, only then you will be paid the amount.
I didn't accept it. They paid And this is, they have received it also on 26/10/2005, they received this.
No. After this, you receive payment.
Under protest, your lordship, that is what I'm saying.
Where is that?
That is, I am showing at page 58 of the read petition, your lordship.
No, 58 is your letter dated 26/10.
Annexure 14.
That is dated 26/10. So let's be very clear now.
26/10.
After this, you were paid.
My lord.
According to you.
My lord.
Which was the date on which you were paid? At the time of receiving that payment, did you record any protest? That's the question. With this letter, they could not have paid you because you are putting so many conditions yourself.
Your lordship, may pass it over. I'm looking at it.
Anyway,
may call it
clarify it. All right. There is confusion on whether the petitioner, the appellant. No, but the single judge says you did receive the payment. That's why it's thrown out.
No, that document I'll check, my lord, because I had given it. It was there. Honorable single judge said that you deposited the entire amount.
Correct, because you've received it.
That receipt, my lord, that was under protest. Your lordship may call it some other day. I'll satisfy, my lord. Maybe next week also.
1 minute.
If
As
Mr. Rao is
reflected in the
there.
order dated 1 minute. I think it's here somewhere. 31/12/2019. All right. You say counsel for the appellant, senior counsel for the appellant, states that he will place on record details of the acceptance by him of the VSS amount
Pursuant to letter date 24/10.
Just read the 3/12/2019 order.
3/12/2019
of the single judge.
Order impugned, my lord.
No. 3/12.
Yes, your lordship. Your lordship is referring to the order was passed on 3/12/2019. Your lordship is specifically. Should I place it, your lordship?
Yes.
The writ petition involves a challenge to the order at annexure 8 as well as annexure 10 therein.
from the pleadings of both the parties and submission made therein, it appears on filing on application to go on voluntary separation scheme. The application of the petition has been accepted subject to 3 conditions as appearing in clause annexure 13 such and such. The petitioner will be relieved from 31/10/2005. As a consequence, he was advised to contact the Joint General Manager of Finance, State Corporation such and such, for receiving the payment arising of the benefits under such and such along with terminal dues, which for the submission of both the counsels appearing for the parties has already been released in favor of the petitioner. The ex gratia on account of acceptance of VSS involving the petition shall be released was dependent on the outcome of vigilance PS case number such and such, which again for the submission of learned counsel appearing in the parties, the vigilance case since has been dropped in the meantime, meaning thereby that the petitioner is entitled to ex gratia amount with interest accrued from the date of entitlement if not relieved. This was also a subject matter before my lordships in a writ appeal, which came to be dismissed by my lord. The third condition imposed therein involved a direction to the petitioner for voluntary withdrawal of the writ petition at hand. It is at this stage of the matter, it appears by annexure 8, the corporation has made some demand against the petitioner in the year 99, but prior to acceptance of VSS involving the petitioner. Considering the submission of the Sodangil learned counsel for the petitioner that for the acceptance of VSS, the corporation is not entitled to continue with any other recoveries. This court is of the opinion that Sodangil is right, but however, this is subject to acceptance of VSS by the petitioner. For the nature of challenge involving the writ petition, this court finds petitioner for not withdrawing the writ petition at hand keeps the VSS matter unnecessarily alive. It is at this stage, this court on the request of Sodangil to learned counsel for the petitioner to take further instruction to drop the writ petition at hand. This matter stands adjourned to tomorrow. This court also observes in the event the petitioner withdraws the writ petition, the VSS aspect will come to an end, meaning thereby there is no possibility of any recovery with the corporation and the demand in the year 99 by annexure 8 will automatically lapse. Put up this matter tomorrow. Now, apart from this demand, my lord, there is a further demand as I was showing to your lordship on 26/12/2005. No,
what were you saying, my lord? Some 2022, there's a writ appeal you were saying? No.
This writ appeal came to be dismissed by my lord because corporation had challenged that order where the lordship directed to refund the amount along with interest, ex gratia amount. That your lordship dismissed. Corporation had challenged.
What was that writ appeal number?
Writ appeal number is,
I think wrong writ
that is there in the list, your lordship.
No, but that's a wrong writ appeal. It's a wrong number. The 314 is a wrong number, sir.
31?
You had given us a number as 314 of 22. That's not the correct
314 of 20, my lord.
That's why you given a wrong number of 22. 22, and so they tagged 22.
Maybe.
So you've got the ex gratia with interest.
Interest, my lord, that is another the subject matter of now a contempt. They paid for only 7 months. They should have paid for 20 months, 20 years. It was due in 2018 years.
All right. You say counsel of the appellant needs to produce documents. Senior counsel of the appellant states that he'll produce documents to show when exactly he received the VSS amount and whether in fact he received it under protest. An affidavit will be filed in this regard for the next date. List along with the record of writ appeal 314 of 2020.
20.
All right. On 1st August.
May I please? This matter relates to appointment of a Anganwadi worker.
We'll take it up on another day, sir. List on 14th August. All right.
Item 42, I pray next week, Millard, on behalf of Mr. Senior Counsel, Mr. Manoj Mishra,
All right.
are appearing for respondent.
At the request of counsel the appellant. List on 11th September.
Item 43, my lord, on behalf of Mr. J.K. Rathar, London Senior Counsel, my lord. His cousin brother passes away today morning.
All
He
right.
has gone for
Request
the-
to counsel for the respondent 11th September. All right.
Obliged, ma'am.
Counting is still not over.
Yes.
Sambalpur is happening when? 10th.
Sambalpur is
10th tomorrow.
20th May.
20th. All right. You see, although the elections to the Bar Council have already commenced and concluded in all the cities, the polling in Sambalpur is to take place on 20th.
20th May.
20th May 2023. List on 31st August. All right.
45, the promotion during pendency of vigilance case, the Lordship
Tomorrow.
fixing to 11th or 11th.
Day after.
Day after.
11th. All right.
Item number 46, my lord. Here, my lord, my prayer is, my lord, for a direction to the BDA authority to conclude the UC case. And your lordship has issued notice. It was sufficient on the BDA, my lord, BDA authorities. And so
Whom
far
are
as-
you for?
I am appearing for the respondent number 5 and 6, your lordship.
So he's there.
Okay.
Do you have any objection to a prayer?
Yes,
Do you have any objection to a prayer?
But since it is pending, my lord, let them take a decision, my lord.
That's what. You say the limited prayer of the. All right. You just say on 28th March 2023, the following order was passed. Today, council appearing for respondents 4 and 5.
Yes,
states here.
No, my lord, 5 and 6, your lordship.
5 and 6 says that he has no objection to the prayer, limited prayer of the appellant being allowed. In that view of the matter, a direction is issued to the officer on special duty under the Orissa Development Authorities Act to proceed with the appellant's UAP case number 57 of 2021. And after hearing the parties, to dispose it off by a reasoned order, not later than 14th August 2023. So the aforementioned case will now be listed before the concerned authority on May.
Both the
2023.
parties will appear, my lord.
For directions on that date, both parties will appear before the said authority
My lord.
and cooperate in disposal of the appeal within the time stipulated.
Obliged.
A copy of this order be sent to the officer on special duty under the Orissa Development Authorities Act, forthwith. The appeal is disposed of in the above case.
My lord, may I please, Your Lordship? My lord, in item 47, 48, and 49, all the three cases are identical. Sir, I beg for some time, my lord, to get the instruction.
At the request of counsel for the respondent, list on 11th September.
Interim order to continue. ma'am.
Interim order. None appears despite a pass over. Dismissed for non-prosecution. All right. Same one. Same one.
Item number 3, I am the OP2.
All right. None appears.
Item 5, your lordship's liberty may kindly be granted.
All right. Permitting the petition. None appears dismissed.
My lord, liberty may granted to raise the plea on the law.
Or permitting the petition.
Item 8, Lordship, same.
Same one.
Item 9, Lordship, file this application for quashing of the entire criminal proceeding. On the ground that, Lordship, the kindly come to the page 15, Lordship.
Yes.
In point 1, the license shall remain valid till 1/7/2022-2021, Lordship. And the petitioner purchased the liquor from the another person.
Well, charge sheet has been filed on.
Yeah, you can take all these pleas, sir, permitting the petitioner to raise all pleas in the appropriate stage. Interim order is vacated. All right. None appears dismissed.
Item 11 raise all the points.
Permitting the petitioner to raise.
Lordship, item 12, may I please, your Lordship? It's the application filing or quashing of FIR, my lord, under section 13(2) of PC Act, my lord. And the FIR dated is 14/6/2018, my lord. Till now, the final form is not submitted, my lord.
We'll ask them to do it immediately, sir. Counsel, the petitioner is aggrieved that the charge sheet has not yet been filed. Perhaps it was not filed on account of the pendency of the petition. While dismissing the present petition, it is directed that the opposite parties should, without any delay, if not already done, file the charge sheet. The petition is dismissed.
Published
with the above assertions. Right.
May I please, your Lordship? Your Lordship, in the present petition, the GR case number 1156 of 2018 has been challenged. Your Lordship, the allegation in brief is that when the petitioner was working as the sub-postmaster, he had made an entry of ₹40,000 to the savings account of one Prasanna Kumar Sahu towards the maturity value of Kisan Vikas Patras. Your Lordship, the allegation is that the petitioner had misappropriated the amount which was supposed to be given to this Prasanna Kumar Sahu. However, your Lordship, I have three grounds on which basis this honorable court may quash the proceedings. The first is that the allegation in the FIR or the complaint do not constitute the offence, that is 409. Your Lordship, if I may kindly draw your attention towards page 11, your Lordship, in the second paragraph.
Yes.
This deposit of ₹40,000 has not been reflected on the SB Lord manual, but the deposit has been reflected on the computerized SO ledger card. Your Lordship, the whole allegation is that the petitioner did not record the transaction of ₹40,000 manually while it was recorded computerized. However, there is not a single allegation to show that there was any loss of the government money. So, your Lordship, when there was no loss of government money, then how it could have been misappropriated?
That can only be tested at the trial, madam.
Your Lordship, there is no misappropriation, your Lordship.
Tested only at the trial.
Your Lordship, it is apparent on the face record, your Lordship, there is no misappropriation.
No.
The whole amount has been accounted for, your Lordship.
It's all right. Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of. All right.
My Lord, against a confirming order, my Lord, I have filed this swearency. The only point is, my Lord, my 457 application have been rejected by both the courts without taking recourse to the section 18 of the Act, my Lord, which is a deeming clause, my Lord. That unless, my Lord, they have served a notice within 90 days to the owner or from whom that has been seized.
You were to take on that FSL report.
That, my Lord, that shows they have supplied, my Lord. So far, item number A1 is concerned, nicotine could not be detected. Therefore, releasing those articles will not, my Lord, harm to anybody, my Lord. Nicotine did not dictated. That is the report, my Lord. Your Lordship will kindly see.
No, but in one parcel, nicotine, B1 nicotine is detected.
Could not be detected.
Next one is nicotine was detected.
My lord. And section 18 says, my lord, if they have not given any notice of confiscation, it will be returned to the owner after expiry of the 90 days, my lord. It is a deeming provision, my lord. And there is also another provision, my lord. If the owner will pay the whole cost, the lordship section 15, my lord. Power to give option to pay cost in lieu of confiscation. That is also there, my lord. Now, my lord, neither they have initiated in confiscation proceeding, nor notice was issued. And the entire thing, my lord, is going to be damaged. After receiving that, I will return back, my lord, by
2013.
My lord,
returning,
my lord, in this case, the way bill was produced. If they will return the articles, I will return to the company.
But it's 2020, now what will...
that is also my return, I will get some money, my lord. That's why, my lord...
Lord, there is a notification prohibiting, my lord, the...
This is a central act, my lord.
If it is released, my lord, again it will be resold, my lord.
No, but what about the procedure?
Procedure, your lordship will kindly see confiscation is section 14 and 15 also, my lord, gives a option to the person to receive the same with a, my lord, specified warning. Section 14, 15, my lord.
No, what will you do if it is released to him?
Released to me, my lord.
What will you do?
Well, I will return back to the company from whom I have purchased, my lord.
You will straight away return it to the company then.
Yes. Then I will get the money, my lord. It is, my lord, they have to initiate a confiscation proceeding.
No.
Till date, my lord,
once it is clear, it does contain nicotine.
One is my lord, serial number 2, that is B, my lord. It is contain nicotine, but A1 does not contain nicotine, my lord. Let them, my lord, release at least A1.
What's the value of that A1?
My lord, more than 5 lakhs, my lord.
30 sealed polythene pouches.
Pardon me.
What is A1 is 30 sealed small polythene pouches. How can it be 5 lakhs? Pan masala, how can 30 packets, small pouches, how can it cost 5 lakhs?
No, total, my lord, it is more than 5 lakhs, my lord.
What?
Total.
Where do you get that?
Seized materials, my lord. I have given the way bill from whom I have purchased, my lord. After giving some warning, my lord.
You want to find out about this?
Yes, my lord.
You say the chemical examination report reveals that the exhibit A1, which is a packet, which is a heat sealed polythene packet containing 30 numbers of small polythene pouches of single quotes Vimal Pan Masala, was not shown to have any nicotine. Whereas the other packet of single quotes V1 tobacco unquote did show the presence of nicotine. Paragraph. Ms. Mahapatra and counsel the petitioner says that at least the packet marked A1 should be returned to the petitioner for being in turn given back to the company from whom the petitioner purchased it. Full stop. She claims the value of this packet A1 to be 5 lakhs or more.
A1 total 5 lakhs. A1, B1 total is more than 5 lakhs.
Then we don't know what A1 is worth. Counsel for the state will inform the court of the present status of the above packet marked A1 and its value.
Yes, ma'am.
On the next date, let's look for the roster bench. On 2nd July.
Oh, sorry to interrupt, my lord. Item 10, my lord. Just is the
yes.
It's a compromise 363 bailable offense. At the time of occurrence, he is minor. Now he is married each other and blessed with a child. The joint affidavit is there, my lord. On only 363 bailable offense.
You're there.
Yes, my lord.
Counsel appearing for opposite party number 3 confirms the affidavit filed by her that she has married the petitioner.
Yes, my lord.
And has been blessed with a child.
My lord.
In that view, the matter takes from the FIR prayer and all proceedings consequent thereto hereby quashed. All right.
Oblige, man. Item 10, man. Oblige.
None appears dismissed. Same order. Same order.
Please, Your Lordship. My lord, Mr. and Mrs. father is admitted in the ICU. He requested to keep it to any other day, my lord.
Counsel of the petitioner is stated to be unwell.
My lord,
Is
may
in some difficulty for it. List on 21st June.
my lord, may I pray one thing? Item 76 also.
All right, same 76.
Obliged. That's why item 19, liberty may be granted to raise
All
also,
right,
please.
right. Permitting. None appears dismissed. Same order.
Item 22, my lord, there are counter FIR case, my lord. In one case, the compromise deed was executed in city case number 1173 of 2014, my lord, under Annexure 3, page 34. And this is CRLMC 21 of 21 on city case number 1172.
The opposite party has not even been served. Debashish Nanda appeared for opposite party number 2. All right. One, Mr. Debashish Nanda is shown to have appeared for OP number 2. The registry will inform him telephonically to remain present on the next date. List on 11 July. Before the roster bench.
May I please, Lords? Item 23, Lordship, notice return answer OP number 2, your Lords.
What's the matter about?
Matter is under section 482 for quashing cognizance order passed by the SDGM Barampur in GR number 231 of 2016, arising out of Bodbazar PS case number 22 of 2016. It is offense under section 493 and 294.
Permitting the petitioner to resolve PCK petitions.
So that's even permitted to service.
Yes.
May I please, Your Lordship? Lordship, I am for the petitioner and the filing for the quashing of the FIR, my lord. That the petitioner filing this case for quashing of the FIR on 6/5/2013, the informant married to the petitioner and which is a copy of the FIR is Annexure 1.
Permitting order. We permit you to raise all, please. Permitting the petitioners to raise all, please, with the appropriate station. Petitions disposed of. None appears dismissed. Same order. Same order. Same order.
Item 29, my lord. This is a case by the wife for maintenance by Annexure 1, my lord. It is of the year 2020. It may be targeted, your lordship. That is the sole reason.
All right. Leaving it open to the petitioner to urge the trial court to expeditiously dispose of the matter. The petition is disposed of. None appears dismissed. Same order. Same order.
Liberty may be given to raise all the grounds.
Which item?
Item 30, my lord. I am attending to BC, my lord.
All right.
Liberty may be given to raise all those grounds at the time.
All right. None appears dismissed.
My lord, total false case has been initiated against the petitioner. Your lordship, annexure 2 is the case, annexure 2, GR case 5 of 2020, pending before the JMFC Nimapada. Annexure 1 is my FIR, and they have taken money by executing agreement, not execute the sale deed, the accused person. So, annexure 1 is the FIR, and counter to this false FIR has been lodged. There is absolutely no material against the petitioner.
Permitting the petitioner to raise all pleas for the proposed stage.
Before trial court, your lordship.
Yes.
GR case 5 of 2020.
None appears dismissed.
My lord, on BC Miller, may be permitted to raise all pleas at the time of.
All right. Permitting. None appears dismissed.
May I please, lordship? Lordship, my prayer is for the quashing of the cognizance by the session judge come special judge Malkangiri. Lordship, FIR has been registered under section 323-506 and lordship section 3 IRS of SC/ST, but charge sheeted under and in charge sheet that section 3 IRS of SC/ST Act has been deleted, lordship. So, lordship, but the cognizance has been taken by the session judge.
I know charge sheet has also been filed. Charge is framed, I'm sure.
And lordship, as because the cognizance has been taken by the session judge, lordship, then I will deprive of the appeal and revision, lordship. My humble submission is that, lordship.
323 is something.
323 is tribal by the magistrate, lordship. So that's why, lordship, my humble submission is that I have also filed.
I know it will all be over. There's never come up for hearing even once.
Pardon, lordship.
There's been no stay. By now it should be over.
Pardon, lordship.
By now the case should be over. There was no stay granted here.
No, lordship.
Yes.
There is no instruction on this regard, lordship.
So it's better to leave it be then.
Then, lordship, urgent the matter, I will take instruction. But today morning I have received instruction that trial has not been.
Where do you say the charge sheet has been filed?
Lordship, that is kindly glance at the cognizance order, lordship.
No, but cognizance has been taken of section. Just see the cognizance.
Lordship, kindly glance at place number 20, lordship.
Yes.
That is last paragraph. Hence, cognizance of the offence under section 323-506-294-34 IPC read with 31 RS 32 BA of SC/ST Act against the accused person, namely Narayan Rai, Dukhu Das, Madhav Rai, and Khokon Gayan. I am not this petitioner, lordship. And under section 323,
who are you?
I am the lordship Ranjit Mandal and Mohesh Deoli.
Yes.
That is 323-506-294 and 34.
All right. You see, Council of the State will find out the present status of the trial. List on the roster bench. 5th July.
Lordship, stay.
Nothing, I see. Nothing's happening. Yes.
Lordship, my petition is there for stay.
Let it be. Let him find out. It's in July only. Right.
Oblige, lordship.
None appears dismissed.
Raise all objection before the trial.
Permitting the petitioner raise all please. All right. None appears dismissed. Same order. Same order. Same order. Same order. Same order. Same order. Same order.
48, no instruction, my lords.
No instructions dismissed. Same order. Same.
No instruction.
No instructions dismissed.
Lordship, item 52, 112 and 115
Become infructuous.
Infructuous dismissed.
3 matters.
All right. No. None appears dismissed. Same order. Same order. Same order.
No instruction.
No instructions dismissed. Same order. I mean, dismissed. Sorry.
Pardon me. Item 53. 53 item.
What is it? Tell us.
Item 53.
Yes.
Infructuous.
Just infructuous. No, infructuous not. Not infructuous, my lord.
Who said it's infructuous?
No.
Tell us what the matter is about, sir.
Yes, my lord. Tell me. My lord, the petitioner is a corporation. Corporation was allotted a dredging work in Hadiyapatha, that is a Mahanadi, Hadiyapatha. So he had engaged one ocean sparkle, and that work at the time of execution of that work, one 3 years old girl was drowned in that pond, my lord.
Well, only format of the affair has been annexed.
Yes.
Praying for quashing of that affair. The substance of the affair is not in the affair itself, man.
All right.
In lower court also, that file is not found, my lord. So
right.
that I have not filed.
It's all right. Nothing will happen then. Permitting the petitioner to raise all pleas at the appropriate stage. All right. And appears dismissed. Same order. 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 Memo taken on record.
My lord,
Dismissed as
66
not
after vacation. 66. My lord, after vacation.
No. Yes. Go ahead and argue if you want to. 66, if you want, you can argue it. What's the matter about? $294. Permitting the petitioner's raise or please of the course. But it is put her name. Permitting the petitioner to raise all pleas.
Lordship, on the ground of compromise for quashing of 68.
You're appearing for whom?
Opposite party. I have given all the amount, Lordship.
All right. Counsel for the opposite party number?
Opposite party number 2, Lordship.
States that he's received the entire amount from the petitioner and does not wish to pursue the matter. That view of the matter taken from the prayer clause. Not proceedings consequent that we hereby question.
Obliged.
None are dismissed. Same order. Same order.
71, Lordship, this is for quashing of a proceeding relating to a matrimonial dispute. The parties have settled between themselves. Notice may kindly be issued to the informant. I am filing an IA for implement of the informant as a party.
You first bring an affidavit and then you file the petition. Sir.
Lordship, I will file the affidavit.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a fresh petition, placing and record affidavits of the opposite party, number 2 and 3, regarding compromise. This post is withdrawn with liberty is prayed for. All right. None appears dismissed.
72, may I please, Lordship? Order of cognizance as well as the proceeding is under challenge, my lord, on the ground of compromise, arising out of a matrimonial dispute. In the meantime, my lord, the decree of divorce has been allowed, And that they've also settled the dispute that the wife is also not interested. OP number 2 is also not interested to proceed in this case. My humble submission will that notice will go and some time may be given. I'll file affidavit to that effect.
You file the affidavit and file it afresh with the affidavit. That's better.
Then
Counsel to the petitioner claims that parties have settled their disputes and a divorce was also being granted. The petition is permitted to be withdrawn with liberty to file a fresh petition, enclosing all the relevant documents, including affidavit of the respondent number 2, opposite party number 2. None appears.
74 may I please not press my lord.
Dismissed as not pressed.
Obliged.
My lord, a small matter that I have filed, my lord, challenging the order of cognizance. I have filed this application. Initially, my lord, FIR was lodged for commission of the offences under section 341, 323, 294, 452, 34 of the IPC. The latter, my lord, it was that final form was submitted on mistake of fact that this case is a false one. For that reason, my lord, that the police personnel filed the charge sheet, my lord, filed the final form that saying that it is a false case. Thereafter, my lord, that complaint petition, protest petitions was filed by the before the Lawrence court below by the complainant, and then, my lord, 2002 inquiry was made, and thereafter that magistrate took the cognizance against the present petitioner for the commission of the offence under section, my lord, 294, 323, 506, 34 of the IPC. Only 506 is the only non-valuable offence. For that reason, my lord, I have filed this application that no case is made out against the present petitioner because that final form has already been submitted. And my lord,
sorry, permitting the petitioner to raise all pleas at the appropriate stage. The petition.
My lord,
we permit you to raise all pleas at the appropriate stage, sir. Right. None appears dismissed. None appears dismissed. Same order.
Permitting the petitioner to raise all the points.
All right, permitting the petitioner to raise all
please, your lordship. My lord, on the basis of my FIR, a prosecution was initiated that your lordship will get at page 10, my lord. Thereby, the accused persons have cheated me by 33 lakhs. This honorable court taken up the 438 application by the annexure 4 and directed that if the total amount with accrued interest is deposited before the court below, then they will be released on bail. Now, I have approached the learned court below for release of the said amount which have been deposited before the court, and the same stood rejected. That is at page 44, 24th December 2022. On the ground, the honorable court has only said for deposit, not for release, my lord. This is what is the substance of the case, my lord. So, admitted they have deposited the amount with the accrued interest that it borne out of record.
302, sir. Read with Acha.
Page 45 is the order, my lord. Relevant portion of the order.
That's right. There's no direction to disburse it to the complainant.
Will your lordship allow
the complainant?
Yes, my lord.
Why should it disburse?
Will your lordship allow me to approach the court which has imposed that condition?
All right. Counsel petitioner seeks leave to withdraw the present petition, liberty to seek other appropriate remedies as may be available to the petition in accordance with law. Disposed of is withdrawn with liberty as paid for.
Item 82, your lordship, Mr. Mrs. brother is admitted in hospital, your lordship.
Counsel of the petitioner stated to be in some personal difficulty today. 11 July.
So item 91 also same.
91 also.
Deep problems.
83, my lords, may I please, my lords, passing of the criminal proceeding, my lords, on the ground of compromise. And that, my lords, the
item 83, I am appearing today, appearing for the OP number 3, my lord.
Yes.
I filed the Bakalatnama along with the affidavit, my lord. In the meantime, the matter has been settled.
My lords, the petitioner and the OP number 3 are now married and they have a,
my lords, a son. Affidavit of OP number 3 is taken in record. Her counsel confirms that she has married the petitioner and and both are residing happily. Full stop. In that view, the matter takes from the prayer clause and all proceedings consequent that to hereby court.
84 point not press move liberty में grant.
Liberty to urge all, please. None of is dismissed. None of is dismissed.
87 may please. In that case, Minister, that the presentation challenging the order dated 2011 to 20 passed by the additional DCP on execute master that the to maintain status quo over the disputed over scheduled property over the scheduled property, but the period of limitation has been elapsed, my lordship. For that reason, I will only be liberty to pay
liberty to raise all, please. Correct.
Item 88, victim girl had already filed affidavit. Can I have a glance annex 3? Reporting code below through special PP.
And then what happened?
When compromise already happened.
Who's appearing for?
No, code below in code below petitioner victim had filed the affidavit through special PP.
Now notice has to go.
Yes, sir. Yes, sir. I'll take a next week.
Counsel for the petitioners claims that petitioner number 1, who has married the victim? Which of the petitioners has married the victim? There are 2 petitioners.
Petitioner number 1
has married opposite party number 3.
Yes, sir.
And they are living happily together. Notice, he accepts notice for the opposite party number 1. Notice will now issue to the opposite parties 2 and 3. Thus the in addition, returnable on the next date.
Stay maybe.
List on 26 June. There shall be stay of further proceedings till then.
Diplomacy.
89, my lord. I am for the informant. And there is a
none for the petitioner. This was an observation.
And the interim order to be
obviously vacated. It's a interim order stands vacated.
May I please, your lordship. Sir, the petitioner challenges the cognizance order.
Before my friend places the matter on merit, I have appeared for the opposite party complainant. Your lordship may kindly peruse order dated 20th of February 2023, my lord. In serial MC number 69 of 2021.
Both 69 and 69 of 2021 and 70 of 2021 arising out of same order, lordship.
Order dated
20th of February 2023, your lordship. Order number 8, your lordship.
Dishonor the check.
Lordship, here the check issued to the complainant on.
So you're not authorized to receive the check. That's what it says, para 4 of the order.
Lordship.
So what are your instructions?
Lordship, in CLMC 69 of 2021, the principal.
See para 4.
Lordship.
Of the order dated 20th February, para 4.
Lordship, kindly allow me 1 week time.
Why go on adjourning, sir?
I'll take instruction.
Counsel, the petitioner is still unable to inform the court whether the complainant is entitled to receive the salary due. Stop. Sufficient time for the purpose was already granted on 20th February 2023, and yet counsel the petitioner wants more time. I think permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed.
Lordship, item 69, in item 69, there is no irregularity. But item 70 may be, the proceeding may be continued. But in item 69, the petitioners have no liability because they are in their name no check has been issued in their favor, Lordship.
What do you say?
My reply is this: if your Lordship kindly turns to the order taking cognizance, it reveals that not only under section 138 of the NI Act, but also under the provisions of 109 read with 420 of the IPC cognizance has been taken. There has been a specific statement in the complaint petition that in connivance with these three accused persons.
Then we'll not change the order. All right, both the one.
Obliged.
Same. 91 lower.
Item 92 and 98. 92 and 98, the similar matters, I will be permitted to take instruction. What is the status of the case, Lord? Because stay has been granted in one case.
It's all right, sir. Permitting the petitioner to resolve at the appropriate stage, the petition is disposed of. Both matters.
The petitioner is the sub-inspector of police, your lordship, is challenging the order of taking cognizance dated 23/12/2002 for the offence under section 294 IPC only, your lordship. Without the order of taking cognizance has been taken without sanction, your lordship.
All that can be raised at the appropriate stage.
Your lordship, kindly see the complaint case. This complainant is very specific. Where the petitioner is the all in all of the police station. That is not police station, that is Phandi, your lordship, and he is the superior officer of the Phandi. Allegation is that while the complainant went to the police station to lodge an FIR without registering the FIR, the present petitioner returned back him by using some obscene word, your lordship. That is the only specific allegation, that is page 11, your lordship.
It's all right.
Only
the petitioner to raise all pleas at the appropriate stage. Sorry.
94. Your lordship. In item 94, the matter has been compromised.
I'm appealing for the opposite party number 2, my lord. Matter has been settled between the parties.
Counsel, the opposite party number 2 confirms that the matters have been settled between the parties.
Lordship, the matter has been committed. Matter has been committed to the special court. Special additional district judge and additional district and session judge come special court POCSO Act under the POCSO Act, Lordship.
What are you saying? So you're opposing the prayer or?
No, no, no.
No, my lord.
Matter
has been committed to Court of Sessions, my lord.
Court of additional district and session judge from special court under the POCSO Act. Matter has been committed. Earlier, the matter has been in the court of JMFC Potamundai. But
all right. That
I am keeping the memo, Lordship.
Yeah. Just take that. And all proceeding consequent that we have a question. All right.
25, my lord. My lord, it is a matrimonial dispute. Matter has been, my lord, resolved through a mediation proceeding as per the direction of this honorable court. My lord, Mr. Vibhu Prasad Tripathi is appearing for the opposite party.
I am appearing for OP number 2.
Where is the affidavit of compromise?
No, compromise affidavit. There has been a compromise before in the mediation proceeding, my lord. The mediation proceeding report is there before your lordship.
All right. When is it? Are those amount already paid?
My lord, 13B application is already filed and amount is paid as per the stipulations in the application.
So where is that order in 13B? Where is that?
13B order is not yet passed, my lord. It is posted to June.
June, is it? All right. It stated that the mediation report reveals that the parties have arrived at a settlement in terms in which a mutual divorce is to be applied for and permanent alimony paid at the request of counsel to the petitioner. List before the roster bench on 10th July. None appears dismissed.
I may please, my lord. This is the petition by which the cognizance order has been challenged by the petitioner, the victim in question. So, the prayer of the petitioner is, let her be permitted to raise the point that taking into ratio the Sakiri Basu and Suri Tambo, the London court below will consider.
Permitting the petitioner to raise all pleas at their proposition. Right.
All right.
None appears dismissed. Both matters. Same order.
Sir, I am the opposite party number 2.
None appears to the petitioner. Put down his name. Dismiss the notice.
My lord, my lord, I support that 2 proceedings are initiated in this matter. So, one by complaint case, allegation is 498A. One complaint case was filed and the police has already initiated a proceeding. So, I only pray that whenever I am the wife, I will be tortured, my lord. So, sir, I say only that one proceeding should continue. The police, the proceeding which has been initiated by the police.
The opposite party, no?
Yes, ma'am. I am opposite party. I am the wife.
Leave it, sir. None is appearing with the petitioner. Yes. None appears dismissed. Same order. Same order.
My lord, item 101 permitted to withdraw, ma'am.
All right. Dismisses withdrawn.
Oblige, ma'am.
Same order. Same order.
106, I am for the opposite party.
All right. None appears to the petitioner. Dismissed.
Understand, my lord, the case has been amicus settled, my lord. The opinion was already appeared and file is affidavit, my lord.
But nobody is there for the petitioner. None appears for the petitioner.
Well, I am for the petitioner, my lord. Well, the case is, my lord, amicus settled, my lord, and the opinion was already appeared, my lord. He has filed an affidavit, my lord, for relating the same, my lord. On 11/8/2021, my lord.
All right. OP number 2 has filed an affidavit stating that he has no objection to the prayer being granted. That view of the matter taken from the prayer clause and all proceedings consequent thereto hereby quashed.
Permitted to raise the.
All right. Permitting the petition to resolve this.
My lord, in this case, the petitioner has filed this application challenging the order passed by the court below, wherein the allegation made by the opposite party in the court below, he being the petitioner is the sister-in-law, my lord, of the opposite party number, my lord. He has made allegation that the petitioner and the other brothers make disturbances in his day-to-day living in his same house. Although the petitioner is residing in the upper first floor of the house. And in the complaint petition, it has been alleged that for last 25 years from the date of the marriage, this petitioner and his other brothers are torturing him and scolding him on the ground that he has given birth of two daughters, my lord. And further allegation that as per the assurance of this petitioner and the other brothers, he has made renovation in the village, my lord, for which 7 lakhs has been made expenses and that has not been returned to him, my lord. So also the other grounds that the petitioner has taken away a sum of rupees 7 lakhs, the money of his mother-in-law, my lord, and that has not been paid to neither to the opposite party nor to his children. Now the petitioner is going to give the same to the son of other brothers, my lord. This is the allegation, my lord. Even if on the self-same allegation, FIR has been lodged, my lord, and the petitioner has been intimated and given his undertaking not to make any disturbances. On the same ground, the DV case has been filed, my lord.
Okay.
The DV is not maintainable since they are residing separately for last 25 years, as per his complaint petition at page 14, my lord.
All right. Permitting the petitioner resolve please. None appears. Same order. Same order.
Pardon your lordships, in item 112, I am for the OP. My appearance
Right,
kindly be recorded.
right. Annapis. Same order.
I mean 116, man. This is an I have prayed for quashing of the affair here on two grounds. One is Lord's jurisdiction, and second is a person is alive. How much 302 is sustainable? Here, this is a case. Can have a glance to page 10 of my brief. In page 10, the wife of the missing person has lodged an affair indicating her husband is missing since 2017. Once he has stated he is missing from 2017, but police, instead of registering a man missing report, straightway has registered a case under section 302 against the father, mother, and brother. And all correspondence, my lord, will find from Annex 3 series and 4 series. He is alive, and due to her torture, she became sannyasi and is residing at Himalaya.
Can raise all these please, permitting the petitioner to raise all pleas at the appropriate stage. All right.
My lord?
If permitted you to raise all pleas at the appropriate stage.
Let's kindly have a glance to the once a person is alive, can a case under section register 302?
All right, sir. That you can point out to the trial court. Yes.
That my lord may confer the report from the police whether he is alive or dead.
That the trial court can do.
But yes. Trial court, this is a case of jurisdiction. You'll also kindly see the page 10 of my brief.
Yes.
But he is missing at Pune.
Right.
They were staying at Pune.
Right.
So jurisdiction of the court as per section 177 of CRPC,
yes.
The jurisdiction is Pune, not in Odisha.
All right. Not interested, sir. Sorry.
At
yes.
least, my lord, kindly observe that, my lord.
Yeah, observed. Yes. None appears dismissed. Same order. Same order. Same order.
My lord, extremely sorry to make a mention, your lordship. There is one matter,